Good morning and welcome to the Public Service Commission of South Carolina. It is Friday, May 24th, I think, 9 a.m. and we are resuming the hearing in docket number 2023-388E and docket number 2023-403E. We have all our commissioners that are present or that are participating are present, and I think we're back to Duke Energy Carolinas. Is that correct?
Chair, the parties have discussed, so Walmart's witness will be the first
Oh,
one
I'm
up
sorry.
this morning. Thank you.
Thank you. Ms. Eaton for Walmart.
Thank you. Walmart calls Lisa Perry.
I believe Ms. Perry's virtual this morning. Is that correct?
That is correct.
Thank you.
Yes, hi, good morning. Can everyone hear me okay?
Yes, ma'am. Thank you, Ms. Perry. I need to swear you in. If you don't mind, would you raise your right hand, please? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Ms. Eaton, you're recognized.
Thank you. Good morning, Ms. Perry. Can you state your name and business address for the record, please?
Lisa V. Perry, 2608 Southeast J Street, Bentonville, Arkansas, 72716.
For whom do you work and in what position?
I work for Walmart, and I am the director of the Utility Partnerships Regulatory Team.
And have you testified before this commission in prior dockets?
Yes, I have.
Did you cause to be prepared for docket 2023-388E pre-filed direct testimony dated April 8th, 2024, consisting of 31 pages?
Yes, I did.
Do you have any additions, updates, or corrections to your pre-filed direct testimony?
No, I do not.
If I were to ask you the same questions contained in your pre-filed direct testimony today, would your answers be the same?
Yes, they would.
I move that the commission accept Ms. Perry's pre-filed direct into the record as if given orally from the stand.
Ms. Perry's pre-filed direct testimony will be entered into the record as if given from the stand.
Thank you. Did you also cause to be prepared for docket 2023-388E 6 exhibits to your pre-filed direct testimony identified as LVP1 consisting of 15 pages, LVP2 consisting of 5 pages, LVP3 consisting of 1 page, LVP4 consisting of 1 page, LVP5 consisting of 1 page, and LVP6 consisting of 1 page?
Yes, you did.
Do you have any additions or corrections to your exhibits LVP1 through LVP6?
No, I do not.
Madam Chair, I further move that the commission accept Ms. Perry's exhibits LVP1 through LVP6 to her pre-filed direct testimony as the next composite hearing exhibit.
Ms. Perry's pre-filed exhibits LVP1 through LVP6 will be a composite exhibit marked for identification as hearing exhibit 20 and received into the evidence of this case.
Thank you. Ms. Perry, did you also cause to be prepared for docket 2023-388E pre-filed supplemental testimony dated May 17th, 2024, consisting of 3 pages?
Yes.
Do you have any additions, updates, or corrections to your pre-filed supplemental testimony?
No, I do not.
If I were to ask you the same questions contained in your pre-filed supplemental testimony today, would your answers be the same?
Yes, they would be.
Madam Chair, I move that the commission accept Ms. Perry's pre-filed supplemental testimony into the record as if given orally from the stand.
Sorry, I'm just trying to find her on my list. Hold on.
Sure.
I'm sorry, you're calling it supplemental, but is that settlement testimony?
It was supplemental testimony.
Okay. Ms. Perry's supplemental testimony will be received into the record as if given from the stand.
Thank you. Ms. Perry, have you prepared a summary of your pre-filed direct and supplemental testimony?
Yes, I have.
Would you please read the summary of your pre-filed direct and supplemental testimony to the commission and the parties in council?
Yes. Good morning, commissioners. Thank you for the opportunity to summarize my testimony and supplemental testimony filed in this docket. Walmart operates 122 retail units in 8 distribution centers in South Carolina, employing over 35,000 associates. In the fiscal year ending in 2024, Walmart purchased $2.2 billion in goods and services from the state. Walmart is a significant customer of Duke Energy Carolinas, with 30 stores and 1 distribution center within their service territory, primarily using the company's optional power service time of use rate, or Schedule OPT. The purpose of my testimony was to address specific elements of Duke's application for an increase in its electric rates. This included examining the proposed return on equity, cost allocation, revenue allocation, rate design, and proposed new time of use periods. Specifically, Duke originally proposed an ROE of 10.5%, which is excessive compared to ROEs authorized in South Carolina and nationwide since 2021, which average around 9.55% in South Carolina and 9.62% for vertically integrated utilities across the U.S. The proposed revenue increase should be examined in light of its impact on Duke's customers, risk-reducing structures like the Grid Improvement Plan rider, which I understand would terminate on August 1st of this year if the settlement agreement is approved as proposed, and currently approved in recent ROEs in South Carolina and nationwide. Duke proposes moving to a 12 CP generation cost allocation method from the current 1 CP summer methodology. If the Commission approves moving away from the 1 CP summer cost allocator that is currently used, we recommend adopting a 4 CP production cost allocation methodology based on Duke's 4 highest peak months to better reflect peak demand costs. Walmart did not oppose Duke's proposed revenue allocation at the requested revenue requirement. If a lower revenue requirement is awarded by the Commission, this reduction could address any interclass subsidies by applying half of the reduction to rate classes with an indexed rate of return above 1.0, while ensuring that no subsidizing class would move to a subsidized position. Walmart supports Duke's revised time of use periods as proposed in its original filing. In order to better align with rate design and cost recovery for the OPT rate schedule with cost causation, Walmart recommends that any decrease in revenue requirement awarded by the Commission should reduce energy charges for this rate class. The purpose of my supplemental testimony is to present Walmart's position to the Commission on the settlement agreement filed on May 17, 2024. Walmart participated in the settlement negotiations but chose not to join as a signing party. Although Walmart is not a signatory to the settlement agreement, in light of the overall revenue reduction, change in capital structure, and Duke's willingness to meet with customers on rate design issues as set forth in the agreement, Walmart does not oppose the Commission's approval of the settlement agreement. I appreciate your time and attention to this case, and thank you again for allowing me to appear today remotely.
Thank you. Madam Chair, Ms. Perry is available for cross-examination by the parties and the Commission.
Thank you, Ms. Eaton.
And one procedural matter, would it be more appropriate for me to stand here while he cross-examines her, or is it going to be possible for Ms. Perry to see me if I have any objection or anything from my table?
She won't be able to see you, but
Okay.
you can sit at your table just
Okay.
and object from your table. Just be sure to use your microphone.
No problem. Thank you.
Thank you, ma'am.
Oh, that's fine. Sure. No problem.
Mr. Hall for DCA.
Good morning, Ms. Perry. My name is Roger Hall. I'm an attorney with the South Carolina Department of Consumer Affairs. Can you hear me okay?
Yes, I can hear you fine. Good morning.
Good morning. You covered some of this in your summary, but I'll just want to go through a few points again. So you discussed some ROE averages in your testimony, is that right?
That is correct.
And on page 9 of your testimony, as you alluded to, you note that since 2021, the Commission has issued orders with stated ROEs in 2 cases, and the average was 9.55. Is that correct?
Correct.
And I believe those were a 9.5 for Dominion and a 9.6 for Duke Energy Progress. Is that right?
Yes.
Okay. And you also cite several national averages in your testimony. Looking at page 10, lines 13 to 19, where you say the average of the 115 reported electric utility rate case ROEs authorized by commissions to investor-owned utilities from 2021 to so far in 2024 is 9.5. Is that correct?
Yes, that's correct.
And you state the range of those authorized ROEs over that period is 7.36 to 11.45. Is that correct?
Yes.
And that's, you conclude that section there and say that as such, the company's proposed 10.5 ROE is counter to broader electric industry trends, right?
Yes.
Okay. You noted that those numbers included distribution-only rates or companies, so then you provided averages without those companies, is that right?
Yes, that's correct.
Okay, and I'm looking at page 11, lines 6 through 10 of your testimony. And you use a group reported by S&P Global and found that the average for vertically integrated utilities from 2021 through present is 9.62. Is that right?
That is right.
And then you state that the trend has been relatively stable, noting that in 2021 it was 9.54, 2022 the average was 9.6, and the average in 2023 was 9.71. Is that right?
Yes, that's correct.
And excuse me, I left out one, and thus far in 2024 it was 9.67.
Correct.
Okay. And then you sort of hone in on the 2023 average of 9.71, but you don't make an actual ROE number recommendation, do you, in your testimony?
No, I do not.
But you do make some recommendations to the commission that you covered in your summary, and so just I'm going to mention one of those. You said on page 4, lines 10 to 15, that the commission, that Walmart recommends the commission, among other things, consider the impact on customers associated with the ROE, in addition to all the other facets of the case, to ensure that any increase in the company's rates reflects, quote, the minimum amount necessary to compensate the company for adequate and reliable service. Is that right?
Yes.
Okay. And you also recognize the DEC needs an opportunity to earn a reasonable return for its shareholders, right?
Correct.
Okay, I didn't want to leave
Correct.
that part out. So then you also use the 9.71 average and DEC's requested 10.5 to discuss the revenue impact of those two ROEs. Is that right?
Yes.
Okay. And you state on your direct page 16, lines 5 to 8, that if the commission were to approve an ROE with 9.71 versus the company's proposal of 10.5, it would result in a reduction of the proposed revenue requirement, inclusive of taxes, of $41.3 million. Is that right?
That's correct.
And that $41.3 million reduction, that would equate to a $41.3 million in savings for all customer classes. Is that right?
Yes.
And I'm going to put it up here on the Elmo so that everyone here can see, but I'm going to put your exhibit LVP4 on the screen. And it looks like you have that in front of you?
I do. I'm flipping to it right
Okay,
now.
well, I'm going to zoom in. Since you can see it all, I'm going to zoom in a little bit for the benefit of the commission and everybody in the room.
Okay.
See, I'm just waiting to make sure to see what everybody can see. Okay. Let's see if I can get it all on there. Back out a little bit, bear with me. Okay, I think that should show it. Did you happen to catch my conversation with Ms. Jiggets yesterday morning?
No, I did not.
Okay, well, we briefly walked through something similar, so I'm just going to do it again for the benefit of the commission to try to explain sort of basically the math behind what you did here. And can you see what I'm showing on the screen to the commission?
Yes.
Okay.
Yes, I can see it.
Okay, so at the top here, and then I'm going to try to circle some things again to point the commission to it. So you're showing the proposed, what Duke had in their application for the capital structure, which was 53% equity and 47% debt, right?
Correct.
And then multiply that times the cost rate, so 4.56. And, oh, I'm sorry, at the top, I take that back. So at the top here, you have your 9.71% average that you used, right?
Right.
Okay, and then essentially you come out with a 7.29% rate of return, right?
Mm-hmm.
And you
Correct.
multiply that by what was in the application for the rate base of roughly $7.4 billion. Is that right?
Correct.
Okay. And then to make the comparison below that, you have all the same numbers, right?
Mm-hmm.
For capital structure and cost of debt. And this time it's the proposed, what Duke proposed as a 10.5% ROE instead of 9.71, right?
Correct.
And that gives you 7.71% rate of return.
Correct.
Multiply that times the $7.4 billion rate base, and you get a couple numbers there, and you show that difference of 500 and actually I'll get to that. You do then incorporate down below net operating income, but essentially you come up and you have a gross up here, right, of 1.33%. That's for
Right.
for taxes, right? So whatever their revenue is, they have to pay taxes. Okay, and then that's how you came up here with your $41.3 million difference. Does that basically summarize how you came up with that?
Yes, that is correct.
Okay. And so in your example, there's a 79 basis point difference in ROE. Is that right?
Yeah, that looks about right.
Okay, so that's that difference here again between, where are we? 9.71 and 10.5, and that's, well, I said 79 basis points in ROE, right?
Yes.
Okay. And we already talked through this, but all the other inputs are the same. The cost of debt's the same. The capital structure is the same. The only different, and the rate base is the same. The only difference in your inputs is the ROE, right?
That is correct.
Okay. So based on that, would you agree that every basis point difference in ROE is approximately, and I can show the math, but is approximately $523,000 difference in revenue?
Subject to check, I will take your word for it.
Okay.
That sounds about right.
And I'll tell you how I did that. So basically we take down here the $41.3 million difference that you had divided by 79 basis points difference. And subject to check, that comes out to $523,236 per basis point.
Okay.
And when we say basis point, that is like a 0.01, right? So a 9.71 to 9.70, that is a 1 basis point difference. Is that right?
That's right.
Okay. So would you agree that if all the other numbers were very similar to this, again, if the capital structure was similar numbers, the rate base was similar, that you would probably also get a roughly $500,000 difference per basis point?
Based on your math, yeah, that sounds like it would be right.
So the settlement has a 51.21 equity structure versus 53. The settlement is based on a rate base of 7.46 billion. You use 7.4, so those are fairly close, right?
Mm-hmm.
So again, you would expect a similar reduction of about $500,000 per basis point in ROE.
Right.
Okay. So if again the settlement provides for a 9.94 ROE. If we said it was 9.9, that would probably be a roughly, that's 4 basis points, a roughly $2 million difference. Would you agree?
Yeah, that sounds about right.
Okay. And for every basis point you lowered that ROE, it would be, everything else stayed the same. It would be a subsequent reduction of $500,000 in revenue.
Correct.
And that would be an additional $500,000 per basis point savings for customers?
Yes.
Okay. Thank you. That's all the questions I have. I appreciate it.
Thank you, Mr. Hall. Commissioners, questions for Ms. Perry? Ms. Eaton, any redirect?
No, thank you.
Thank you. Ms. Perry, I understand it's early where you are, so we certainly appreciate you being here this morning and giving us your testimony. And you may stand down, and we wish you a good day.
Thank you. You as well.
Thank you.
Thank you.
Madam Chair, with agreement of the parties, we would call Mr. Pollock for example.
Mr. Elliott, you're recognized.
Mr. Pollock is testifying virtually, Madam Chair.
Okay. Well, it'll take a minute, and let's get him. But good morning, Mr. Pollock.
Morning, Madam Chairman. How are you?
I'm fine, thank you. Would you raise your right hand for me and let me swear you in? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. Mr. Elliott?
Thank you, ma'am. Mr. Pollock, would you state and spell your last name for the court reporter, please?
Jeffrey Pollock, Pollock.
And Mr. Pollock, by whom are you employed, and what do you do for a living?
I'm employed at J. Pollock Incorporated. I'm an energy advisor and regulatory consultant.
Thank you. Now, Mr. Pollock, have you prepared and caused to be profiled with this commission 33 pages of direct testimony?
Yes, sir.
And have you filed both confidential testimony and redacted testimony?
Yes.
All right, sir. And attached to your direct testimony, did you attach 3 appendices?
Yes.
And in addition, did you attach to your direct testimony 7 exhibits?
Yes.
Have you had the opportunity to review your direct testimony, appendices, and exhibits prior to your appearance here this morning?
Yes, I have.
Do you have any changes, additions, revisions, corrections to your testimony or appendices or exhibits?
No.
With respect to your testimony, if I asked you those same questions again here this morning, would your answers be the same?
Yes, they would.
Thank you, Mr. Pollock. Indulge me 1 minute. Madam Chair, we would move the confidential and redacted direct testimony of this witness into the record as if given orally from the stand.
Mr. Pollock's testimony, both versions, confidential and public, will be entered into the record as if given from the stand, and the confidential version will be maintained as confidential.
Thank you, ma'am. And I would also move Mr. Pollock's 3 appendices and his 7 exhibits into the record, and would suggest they be entered as a single composite exhibit.
Mr. My notes may be wrong. I have appendices A through D. Is that incorrect? In my notes.
Let me check.
I apologize. I just want to make sure we do the.
I beg your pardon. There are 4. There is a D.
4 appendices.
Yes.
A, B, C, and D.
Okay. And 7 exhibits.
Yes, ma'am.
Okay. Thank you. Mr. Pollock's pre-filed appendices and exhibits will be a composite exhibit marked for identification as Hearing Exhibit 21 and received into the evidence of this case, and the confidential portions will be maintained under seal.
Thank you, ma'am. Mr. Pollock, next, let us turn to your surrebuttal testimony. Did you cause to be prepared and pre-filed with this commission 19 pages of surrebuttal testimony?
Yes.
Have you had the opportunity to review that testimony prior to your appearance this morning?
Yes.
Do you have any changes, corrections, revisions to your surrebuttal testimony?
No.
If I asked you those same questions here this morning, would your answers be the same?
Yes.
Thank you, sir. Madam Chair would move the Mr. Pollock's surrebuttal testimony into the record as if given orally from the stand.
Mr. Pollock's surrebuttal testimony will be entered into the record as if given orally from the stand.
Thank you, ma'am. Mr. Pollock, have you prepared a summary of your direct and surrebuttal testimony?
Yes.
Would you please present that to the commission at this time?
Certainly. Good morning, Commissioners, and thank you again for the accommodation to appear this morning virtually. My testimony addresses class cost of service study methodology, specifically whether a change from a summer coincident peak to a 12 coincident peak method is warranted. I also address the importance of reducing class subsidies and apportioning the base increase that may be authorized in this case. And finally, address the company's proposed changes to its time of use rating periods and the incentive margin in its hourly pricing rate schedule. First, regarding cost of service methodology, my recommendation is that no change is warranted. Duke Energy Carolinas is still a summer peaking utility, and it projects to remain summer peaking. This is important because in order to provide reliable service, the utility must install sufficient generation capacity to meet the expected peak demand of its customers and to provide an adequate reserve margin. By providing capacity sufficient to serve the expected peak demand, this capacity is also available to meet the demands in the other months. In other words, meeting the annual system peak is the cost causer, while meeting the demands in the other months is merely a byproduct. Thus, consistent with cost causation, a utility like Duke Energy Carolinas with pronounced seasonal peak demands should allocate production and transmission plant costs relative to each customer class's contribution to those peaks. We recognize that DEC also has a growing winter peak, so it would not be unreasonable for the Commission to consider averaging the summer and winter peaks, but 12 CP would be completely unreasonable. This case also presents an opportunity to reduce the current interclass subsidies. The company had proposed a 10% reduction. SCEUC proposed a 35% reduction, thus achieving cost-based rates much sooner, perhaps even in my lifetime, while not causing any rate shock for any major rate class. SCEUC also believes that rate design should benefit customers. The company's proposed time-of-day rating periods would all but eviscerate opportunities for manufacturers to shift load to lower their costs, which would in turn lower costs for all customers. That stated, the settlement, which will reduce subsidies by about 23% while also retaining the current scheduled HP incentive margin and time-of-day rating periods, pending further collaboration by interested parties, is fair and reasonable and in the public interest. We urge you, therefore, to approve the settlement. Again, thank you for your time and attention.
Thank you, Mr. Pollack. Please answer any questions the Commission may have.
Mr. Hall,
No questions for this witness. Thank you.
thank you. Commissioners. Commissioner Caston.
Thank you, Madam Chair, and good morning, Mr. Pollack.
Good morning, Commissioner Caston.
I think you answered those questions in what you just said, but were you able to hear Ms. Hager's testimony yesterday and questions that were asked and her answers relative to 1CP and 12CP?
I understood she was asked several questions about that. Unfortunately, I was not able to participate yesterday.
Well, I'm going to attempt to give kind of a summary, and I think Ms. Hager comes back up later, and if I screw this summary up, she'll fix it. But in essence, I think she basically stated that her support for 12CP as a more equitable means for cost allocation, which is, I think, contrary to what you just said, and further stated that for generation planning, I think she just said generation. I don't know if it was generation and transmission planning, but for generation planning in particular, DEC for planning purposes still uses the peak, the max peak.
Yes.
Does that change anything, or do you still disagree with that, or?
I don't disagree. I think if you look on page 12 of my testimony, I put a chart in there that shows the monthly peak demands as a percentage of the annual system peak. And I think having that picture might help my explanation a little bit. So I would invite you to look at that chart, and what that chart will reveal is it shows each of the monthly peaks, and this is over the period 2018 through 2022. And note that the peaks are blue, and then the months where the demands are 90% of the system peak are denoted in red. And you can see that at least for the period from 2018 to 2022, pretty consistently, DEC had a summer peak, pretty strong summer peak actually. And you can see the evidence of a winter peak in January of 2022, or in January of the test year. If we were looking at using 12CP, and if that was a reasonable method, what that chart would look like, it would be all red.
Okay.
In other words, you see very little difference between the monthly system demands. And I've seen utilities with system loads like that. They're very few and very rare, but there are systems like that. I'd say the vast majority of utilities have patterns that are very similar to what DEC is using, and physics still demands you have to have the right amount of capacity if you want to keep the lights on.
I think Ms. Perry with Walmart recommended that if the commission opted to agree to go away from 1CP, I think she recommended 4CP. Let me ask this. If 12CP has issues, as you say, when will they start manifesting themselves? What would be the significant issues?
You mean if you adopted a 12CP, then what would the consequence of that be?
Yes.
Well, I think the consequence would be that if you design rates based on 12CP, you're basically saying it doesn't matter when I use electricity, and therefore I'm going to use as much in the hot summer and in the cold winter as I use all year round, and I'll have no incentive at all to cut back during the hottest summer days or the coldest winter days, because the price signal won't tell me to cut it back. So we like to set rates that reflect cost too, and to the extent that costs are allocated on 12CP basis, it kind of means that rates won't have seasonal differentials. They maybe have very minimal time of use differentials, as I think in this case here. And I think that sends the wrong price signals to customers. I think you want customers to respond to price signals. It's better for them. It's better for the system overall. It's better for all customers.
Who or what class of customers would benefit more from 12CP than 1CP or 4CP?
I don't know about who benefits more in terms of it obviously determines what share of the cost is borne by each customer class. I'm certainly not going to deny that industrial customers who tend to have more steady usage throughout the year and tend to have to pay higher rates under 12CP than under, say, a summer peak or an average of summer and winter peak. That said, if it was a 12CP system, I would be recommending 12CP, but it's not a 12CP system, so I'm not recommending that. But to the extent that the weather-sensitive classes are allocated less cost, because you're effectively saying it doesn't matter when I use electricity, the harm is that they may benefit in the short run by having a little lower rate. The harm is they have no price signal, and therefore costs are going to continue to rise as the company continues to add more capacity to serve that load.
So if I'm understanding this correctly, you're saying that with a 12CP, there will be no incentive considering cost causation regardless of whether summer or winter for a customer to keep their thermostat higher in the summer to hold that peak down, and which I think you're saying the peaks would possibly go up, which would require more generation, which would require greater cost. Is that in essence what you're saying?
You repeated exactly what I said, sir. Yes.
Okay. Thank you.
Thank you.
Commissioners, further questions for this witness? Mr. Elliott, any redirect?
No redirect, Madam Chair. Now, as I understand it, Mr. Pollock can continue to be made available, but would have conflicts at some times during the next several business days. So he'll be available, but I would might need some accommodation if he were to be recalled.
Thank you, Mr. Elliott. I appreciate that. Mr. Pollock, thank you for your appearance this morning, for being here with us early, and you may stand down. Thank you very much and have a good day.
Thank you so much, and you have a good day too.
Thank you.
Thank you, Chair Belzer. At this time, the company calls Mr. Steve Fetter. Mr. Fetter will be appearing virtually.
And once again, parties, thank you very much for working with each other to accommodate the witnesses' schedules. It helps us out tremendously, so thank you.
Thank you, Chair Belzer.
Mr. Fetter, do we have you?
Yes, I am here.
Good morning, Mr. Fetter. Would you raise your right hand and let me swear you in? Do you solemnly affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. Yes, sir.
Thank you, Chair Belzer. Mr. Fetter, would you please state your name and business address for the record?
Stephen M. Fetter, 1240 West Sims Way, Port Townsend, Washington, 98368.
We have a new court reporter today, counsel, so I need for y'all to identify yourselves so that
I apologize, Chair Belzer.
and
Brandon Marzo on behalf of.
That's on me. I didn't say that earlier today, so
That's fine.
thank you.
And Mr. Fetter, can you tell me about whom you're employed and in what capacity?
I have my own energy advisory firm called Regulation Unfettered, and I am the president.
And have you prepared or caused to be prepared under your supervision direct testimony of 26 pages that was previously filed with the Commission on January 4th, 2024 in this docket?
Yes.
And do you have any changes or additions to your pre-filed direct testimony?
No, sir.
And if I asked you the same questions today, would your answers be the same?
Yes, they would.
Have you prepared or caused to be prepared under your supervision one exhibit labeled Exhibit A that was previously filed with the Commission as an attachment to your pre-filed direct testimony?
Yes.
Do you have any changes or additions to your pre-filed direct exhibit?
No.
Thank you, Mr. Fetter. Chair Belzer, at this time I would move that the pre-filed direct testimony be admitted into the record as given orally from the stand, and Mr. Fetter's direct exhibit A be marked for identification and moved into the record.
Mr. Fetter's pre-filed direct testimony will be received into the record as if given from the stand. Mr. Fetter's pre-filed direct exhibit A will be marked for identification as hearing exhibit 22 and received into the evidence of this case.
Thank you, Chair Belzer. Turning to your rebuttal now, Mr. Fetter, have you prepared or caused to be prepared under your supervision rebuttal testimony consisting of 11 pages that was previously filed with the Commission on April 22nd, 2024 in this docket?
Yes, I did.
Do you have any changes or additions that you need to make to your pre-filed rebuttal testimony?
No, sir.
If I ask you the same questions here today, would your answers be the same?
Yes, they would.
Okay. Chair Belzer, at this time, I'd move that the pre-filed rebuttal testimony, Mr. Fetter, be admitted into the record as if it were given orally from the stand.
Mr. Fetter's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Thank you, Chair Belzer. Mr. Fetter, have you prepared a summary of your direct and rebuttal testimonies?
Yes, I have.
Okay. With your permission, Chair Belzer, I ask that Mr. Fetter be allowed to read his summary.
Yes. Mr. Fetter, please go ahead.
Thank you, Chair Belzer. Chair Belzer, Vice Chair Powers, and fellow commissioners, my name is Stephen Fetter, and I serve as president of Regulation Unfettered, my utility advisory firm. Prior to that, I served as utility group head at Fitch, a credit rating agency based in New York and London. Earlier, I served as chairman of the Michigan Public Service Commission. As a state utility commission chairman, head of a major utility credit ratings practice, and currently consultant to regulated utilities, public utility commissions, and consumer advocates, it is my opinion that the core principle of rate making is the attainment of just and reasonable rates that are fair to both the utility and its investors and also its customers. Part and parcel of this concept is rate setting that provides the utility with a reasonable opportunity to recover its prudently incurred costs and a fair return on its prudent investment. The extent to which regulators meet these goals defines whether a constructive regulatory environment exists, a crucial element to providing a regulated utility with the financial integrity necessary to maintain reliable utility service while attracting needed funds from investors. Applying these rate-making constructs, I conclude in my direct testimony that environmental coal ash compliance expenditures are integral to the operation of DEC's generating plants located in North Carolina. Those generating plants have provided electricity for the benefit of customers in both South Carolina and North Carolina for decades, and if they are to continue to do so, it will only be as a result of DEC having met the environmental compliance requirements under both federal and North Carolina state laws. As such, fairness dictates that all customers who have historically enjoyed the electricity provided by these plants and will continue to do so should share in paying those compliance costs on an allocated basis. Importantly, I am not aware that compliance activities have been carried out imprudently, nor have I seen a reasonable alternative electricity supply if the low-cost power from the North Carolina plants were to come to an end due to non-compliance with federal or state laws. Rather, what is clear to me is that the shutting down of those plants due to non-compliance would be detrimental to both North Carolina and South Carolina customers. In my rebuttal testimony, I address multiple witnesses' assertions and recommendations regarding the recovery of coal ash costs. I offer the caution that opposing witnesses are espousing views that some North Carolina environmental compliance statutes came about on a direct line from improper behavior at Duke Energy, a view that has been explicitly rejected by both the North Carolina Supreme Court and the North Carolina Utilities Commission. Regarding DCA witness Borden, I accept his statements that he does not provide an opinion on whether coal ash removal costs were prudently incurred, and thus I reject his recommendations that the Commission consider partial or full disallowances of environmental compliance costs and not allow a rate of return for coal ash basin closure compliance costs. With the utmost respect, I believe that this Commission should allow full recovery of all appropriately allocated prudent costs related to the North Carolina generating plants at issue in this case. Finally, as has been mentioned by prior company witnesses, the ORS, DEC, and all but one intervener has entered into a settlement agreement that was filed with the Commission on May 17, 2024. If approved by this Commission, that settlement would resolve all contested issues in this proceeding. During my tenure as chairman of the Michigan Public Service Commission, I was a strong proponent of resolution of contested cases through settlement, since parties would be certain upfront what the final decision would be following regulatory approval of the agreed upon terms. Accordingly, I support the settlement agreement as a reasonable resolution of this case, and I encourage this Commission to approve the settlement agreement without modification. Thank you.
Ms. Chair Belzer, Mr. Fetter is available for cross-examination by the parties and questions from commissioners.
Thank you. Mr. Hall?
Good morning, Mr. Fetter. My name is Roger Hall. I'm an attorney with the South Carolina Department of Consumer Affairs. Can you hear me okay?
Yes, good morning, counsel.
Good morning. I think from your summary, this is clear, but would you say you've been submitted as a general policy witness in this case?
Yes.
Would you say prudency has a lot of focus in your testimony?
Prudency has been the touchstone of my activities for the past 37 years related to regulatory questions.
And you're not a rate of return witness, right?
I am not a rate of return witness.
But you do talk a lot about fair rates of return?
Can you direct me to that?
Sure. I'm looking at page.
Sorry.
Gentlemen, one at a time. I know there may be a little bit of lag, Mr. Fetter. I'm sorry, but let's one at a time, please.
I will go slower.
As will I, Madam Chair. Sorry. Yes, Mr. Fetter. Looking at page 7, and I think there is a bit of discrepancy. So depending on how you look at it, I see it as PDF page 8, but page 7 of your direct, or perhaps page 8. I think I have it here, but it's the line that starts. Bluefield held the return should be sufficient to assure confidence.
What line again, counsel?
I apologize. I do not have the line, but let me
Line
see if I can
20.
find it.
Page 7, line 20.
Okay, I'm there.
Okay, and it discusses the Bluefield holding about returns. Is that right?
Yes.
Okay. You also talk about constructive utility regulation in your testimony. Is that right?
I do.
Okay. And I'm looking at your direct page 10, and you state regulation should be, quote, consistent and steady over time. Does that sound right? And I'm sorry I do not have the line again, but take your time and find it. Don't want to misquote your testimony.
Okay. Yes, it says, in addition, my own perspective of constructive utility regulation is that which aligns the seemingly competitive interests of utility investors and utility customers in a manner that is consistent and steady over time so that all parties have reasonable expectations about how regulatory policy will be effectuated.
Thank you. And at the bottom of that, to stay on that page for me, please, at line 27, you also say that constructive regulation is efficient and predictable. Is that right?
Constructive regulation is efficient and predictable with a long-term focus on stable rates while also recognizing the need for timely recovery of costs and the value to customers of a financially strong utility with ready access to the capital markets at attractive rates, even when the financial markets are under stress.
Okay, thank you. And would you agree that South Carolina has been generally constructive towards Duke Energy Carolinas?
Yes.
Okay. And Duke Energy Carolinas has been able to raise money and fund the improvements in this docket, is that right?
Yes.
Okay. Going over to page 11 to 12 of your direct testimony, and you discussed the regulatory analysis you did for Fitch.
Tell me where I'm at again. Where you're
I'm
at
sorry,
again.
I don't have the pages, but you worked for Fitch, correct?
I was head of the utility ratings group at Fitch.
Okay.
I'm sorry to interrupt, Mr. Fetter. I need for you to be careful where you're holding your paper. Sometimes you're reading from your paper and it's covering your face. And
I'm sorry.
it's okay. Our court reporter likes to be able to see faces when she's recording. So
I will be better behaved.
It's. I understand the tendency. It's just a request, please. Thank you.
Yes, Chair.
Okay, and so I believe I'm still on page 11 or 12 of your direct, but you discuss how rating agencies adjust credit ratings up or down depending on regulatory advantage. You see that?
I have a quote from S&P that begins with the word regulatory advantage. It's a long quote.
Well, let me hold off on that for now. I don't need, not asking you to reread your testimony to us. There are a few sections I might have you read, but would you generally agree that in your testimony, you discuss how rating agencies adjust credit ratings up or down depending on regulatory advantage?
Yeah, regulatory regulation is probably the most important qualitative factor that goes into credit ratings.
Okay, and again, we talked about you believe that should be consistent, steady, and predictable, correct?
Yes.
Okay, thank you. So, Mr. Feder, if a commission were concerned that a utility had been over-earning and customers overpaying for years, how would the commission fix that in the light of the need for consistent, steady, and predictable regulatory environment?
It may vary state to state, but a commission could issue a show cause to begin a rate proceeding, or if there are regularly scheduled rate proceedings, then the commission could look at those issues within either of those methods.
Okay. Right, and so because of the constructive regulatory environment, that's part of it, but right, commission has to balance fair, just, and reasonable, right?
Yes, the goal should be fairness across the board to all stakeholders.
Okay, now I am going to try to show you something on the Elmo here, but to give you a second to look for it, I believe I'm looking at page 10 of your direct, and while I've looked for it, I'll just say it's a quote about Lesser and Giacchino, if I said that right.
I see a quote at the top of the page about regulatory compact.
Okay. This one's kind of long, so let me put it on the screen for the commission first, but then I will ask you to read it once I get this set up. And bear with me again, just want to make sure the commission will be able to read this. It's a long quote. Okay, sorry, Mr. Feder, I think we've got it set up. Would you mind reading, starting there from the highlighted portion and continuing through the underlined?
In the above noted reference book, Lesser and Giacchino describe that under the regulatory compact, and now begins the quote, the regulator grants the company a protected monopoly, essentially a franchise, for the sale and distribution of electricity or natural gas to customers in its defined service territory. In return, the company commits to supply the full quantities demanded by those customers at a price calculated to cover all operating costs, plus a reasonable return on the capital invested in the enterprise. The first half of this compact protects the company from would-be competitors and secures for the public the substantial economies of scale available in the large-scale production of electricity. The second half of the compact counteracts the injurious tendency of monopolies to raise prices above the level that would prevail in a competitive market.
Thank you. And you agree with that that statement, I assume, since it's in your testimony, right?
Yes, I think that's a reasonable statement.
Okay. So if Duke Energy Carolinas, their parent company, Duke Energy, decided not to invest in South Carolina solely because it could get a higher return in another state, that would not be honoring the regulatory compact, would it?
I think Duke Energy has a responsibility to provide sufficient investment in each of its subsidiaries to assure reliable service at just and reasonable rates. I don't view, in fact, after you discussed this yesterday with a witness, I gave it thought overnight, and it reminded me, my wife and I were just traveling, and I saw a necklace that I thought my middle daughter would really like. And as I went to purchase it, my wife said, "What will we get for our other two daughters?" And I said, it does not have to be an even up transaction in all cases. And we purchased the single necklace. And so in answer to your question today and relating back to yesterday, I think Duke Energy has a responsibility to make sufficient investment in each of its subsidiaries to assure reliable service at just and reasonable rates. It does not have to be an equal investment across the board.
Thank you. I appreciate that. That's a very good analogy. In your testimony, you also discuss coal ash issues. Is that correct?
I do.
Okay, and I'll just go ahead. I'm looking at page 13 of your direct.
I'm there.
Okay, and I've got it on the screen here just again for the benefit of the commission. It's not, this one's not quite as long, but will you read the highlighted portion starting at line 15 through 18?
Accordingly, I strongly believe that fairness dictates that all customers who have previously enjoyed the system benefits and/or will continue to do so if those North Carolina generating plants continue to operate should share in paying those costs that on an allocated basis. It looks like there might be a little blip there, but the idea is clear.
Thank you. And you testified in the Duke Energy Progress case in 2022 also, right?
I did.
Okay. I don't know if you have that. I recalled you testifying there. So I pulled it up, and I'm just going to show you there was one difference in your testimony in that case to this one, and I just kind of want to make sure you still believe it because it's not in this testimony. I'm putting it on the screen. And I will submit to you, this is from docket 2022-254E, and is your direct testimony, page 13 from that. And so here, submit to you, I can give you a chance to read it maybe while I'm talking, but that the highlighted part, I believe, is the exact sentence you just read. And then afterwards, can you read that for me, starting with the only caveat?
The only caveat I would offer is that customers should not pay for costs resulting from imprudent decisions or actions, a view I have consistently held while serving as a regulator and during the 2 decades I have served as a consultant to utilities, commissions, and consumer advocates. I note that concept appears elsewhere in this year's testimony.
I agree, and so I was going to ask if you've held that opinion for decades, and so you still hold that opinion now, right?
I do, as I think in this testimony I refer to it over the last 37 years, so it's been a while.
Yeah. And then starting on page 14 of your direct testimony in this case, you also discuss the concept of prudency as it relates to DEC's coal ash in this case. Is that right?
You don't have a line number, right?
I might. Let me see. But would you agree that you generally discuss prudency as it relates to DEC's coal ash in this case?
Yes.
Is it your testimony that DEC's actual expenses in this case are prudent?
I defer to witness Bednarsik of the discussion of the specific coal ash remediation expenditures. I am saying that if found to be prudent, they deserve to be recovered.
And so, right, because you did not review the expenses or construction plans or anything else to determine if they were prudent. Is that right?
No, I was just including in my testimony the regulatory concepts of prudency and imprudent behavior.
Okay. And so we asked in discovery whether you were providing an opinion on prudency of specific cost in this case. I'll submit to you, we did not get a yes or no answer, but so you would say, no, you are not providing an opinion on the prudency of specific costs, correct?
That would be accurate.
Chair Belzer. I know the witness can't see me.
Just a moment.
Chair Belzer, I'd ask that if we're going to talk about a discovery response, that be presented to the witness so that he can then elaborate as to what was said and what was intended.
Mr. Hall, do you have the discovery response?
I do.
Is it confidential?
It is not.
Thank you. Can you are you trying to put it on the Elmo?
Yes.
Thank you. Does the question appear at the top of that?
Yeah, let me back out just a little bit.
Thank you. I think we can see that.
And let me, I'll put this is the cover page. So I will submit that it was not provided by Mr. Fetter. It doesn't indicate it was provided by Mr. Fetter. I believe it does look like it came from Mr. Marzo, who I don't believe I've met, but I believe Attorney Marzo who's just speaking. So this is the discovery response to DEC's discovery question 2-44. Do you see that?
Mr. Hall, can you lay a foundation as to whether the witness has seen this discovery response, please?
Sure. Mr. Fetter, did you help participate in discovery responses?
You're speaking of discovery responses generally, as opposed to the one that is on the screen.
Yes.
Yes, I did participate.
Okay. And I'll submit I was not going to put this up, but it was requested by Duke's counsel, so I'm going to show it to honor that request. So let me see if let me zoom out so everybody here can see it. So do you see 2-44? This is DCA's question. Is witness Fetter providing an opinion on prudency of specific cost items in this case? Do you see that?
Yes, I will read through it if.
Okay, well, let me ask you first. You would agree that's a yes or no question, isn't it?
Mr. Hall, let the witness read through it,
Okay.
please, if
Sure.
you don't mind. Thank you.
I've read through it.
Is that an accurate depiction of your testimony?
I believe I recall counsel might have drafted the language and run it by me. And I think it's accurate.
Would you agree that the question is a yes or no question?
Can you put it back on the screen, please?
Just waiting for it to, can you see it? And I'll say, I'm sorry to interrupt your thoughts, but I wasn't going to put it up. I think you had already answered the question when you said, no, you were not providing it
But I think you're putting it up to compare it to my answer. As I mentioned, witness Bednarsik reviewed specific items, and so my testimony is that if specific cost items were prudent, they should be recovered. Ms. Bednarsik was the one who would review the specific cost items and make the case on prudency.
Okay. Thank you. And so I guess you would agree if the costs were imprudent, DEC should not be allowed to recover them, right?
My view is imprudent costs should not be recovered.
Okay. All right. I'm looking at page 3, line 10 of your rebuttal. Do you see it where it says it starts, I reject, I have it as Mr. Borden. You might have said his, but I reject Mr. Borden's recommendations?
What line did you have?
And actually, I found it. I do have this printed. I'll put it on the screen for you, and so the commission can see it too. Can you see that, the highlighted part starting with line 8?
Yeah, should I read it?
I can read it if you want, and just tell me if it's right. I think we can all see it in the room to verify, but it says, I accept Mr. Borden's statements that he does not provide an opinion on whether coal ash removal costs were prudently incurred. And thus I reject his recommendation that the Public Service Commission of South Carolina, quote, consider partial or full disallowances of coal ash remediation costs, and quote, not allow a rate of return for coal ash related mediation costs. Do you see that?
Yes.
So we've established that you did not review the cost. You were not providing an opinion on specific cost, right? You defer to Ms. Bednarsik.
As we discussed, I am saying that for specific costs, if they are prudent, they should be recovered.
So I just want to ask, if you are not providing that opinion as a specific cost, you cannot say they should or should not be rejected, can you?
Well, I'll tell you the problem with Mr. Borden's testimony, in my eyes. Mr. Borden explicitly states that he's not offering an opinion on whether the costs were prudently incurred.
Can I just stop? I'm sorry. Go continue.
He then proceeds to say that he's not offering an opinion on which law or regulatory policy would be relevant to his recommendations. And then he seems to provide a reading list for the commission to go through various NARUC and other publications, some media discussions of Duke Energy, and then he invites them to consider partial or full disallowances of coal ash remediation costs and not allow a rate of return, I guess based on if the commission chooses to do that reading list and come to that view. What further struck me is that if Mr. Borden was not going to offer specific determinations on prudency, it struck me as strange that he should say the commission should consider partial or full disallowances. It would make sense for him to say the commission should consider partial or full disallowances or full recovery of coal ash remediation costs. And that's what surprised me in reviewing his somewhat misdirected testimony.
I appreciate that. I guess I'll just ask the question I asked a minute ago. And I believe, you can correct me if you want to change your answer, but you said, I asked you, you would agree if the costs were imprudent, DEC should not be allowed to recover them. And I believe your answer was imprudent costs should not be recovered. And I believe that's all.
Imprudent costs
Chair
should
Belzer, I
not be
think this was
recovered.
asked and answered. I mean, we've covered this several times.
I'm going to allow him to answer because I just want to hear a yes or no. It's a yes or no question, and I didn't hear a yes or no.
Thank you, Mr. Fetter. I will move on. Well, actually, let me go back. Since the chair wanted a yes or no, I believe you did answer yes or no previously, but you would agree if the costs were imprudent, DEC should not be allowed to recover them, correct?
Yes, if costs are imprudent, the EC should not recover them.
Thank you. Okay, I'm moving to the bottom of page 24 of your direct, going into page 25.
I'm there.
And you see the line that says, I view a prudent decision.
Yes.
Okay, could you read that?
I'll start at the beginning of the sentence if that's okay.
Yes, thank you. Go ahead.
Now, specifically regarding legal requirements spanning multiple jurisdictions that share their ultimate purposes, though perhaps not the exact same steps to reach those ends, I view a prudent decision to be one that is made by a person with skills appropriate for the subject matter that falls within a range of reasonable results based upon the circumstances that existed at the time the decision was made.
Okay. So, in your opinion, is part of prudency for a utility to reasonably identify feasible alternatives?
Could you say that question again, please?
Yes, is part of prudency for a utility to reasonably identify feasible alternatives?
I view it is up to the utility to consider potential steps or alternatives and then make a managerial judgment of how to proceed. And then that prudency is measured on the reasonable standard of the decision at the time it was made.
Okay. Is part of prudency to show an investment is necessary?
I would say that necessity would be a part of prudency, but would not be a mandatory portion of that analysis.
And so part of a feasibility analysis, should a utility use current cost numbers?
I think feasibility would include current cost numbers and forecasted numbers.
Do you agree that actual cost would be better than estimated costs?
It depends when the expenditures are going to be made. So you can't have actual data for future costs. And so utilities are always making judgments on the future financial impacts.
Do you agree? Would you agree that within the energy sector, circumstances can change within a matter of months or even weeks due to fuel volatility?
I'd say they could change even more quickly than weeks.
So again, wouldn't actual costs be better than estimated costs due to that changing volatility?
A utility has to plan on a going forward basis, and so it has to make forecasted judgments which then get measured on a prudency standard based on knowledge they had at the time they made that judgment.
So you would say it's important just to make sure that the knowledge they have at the time is the best information to make the decision. Would you agree?
the knowledge they have at the time is to make a decision that has future financial impacts on it, like buying fuel or a purchase power contract that will run out a certain number of years. They clearly can't know which direction the market's going to go up or down during those future years. So they make a judgment based on what they know now as to the contract they're entering into. And eventually they have to defend that decision before the commission.
And admittedly, it probably wasn't a great question, but thank you for your answer. If in doing the estimates, if a company relied on stale data, that would that could impact the prudency of a decision. Would you agree?
The quality of the data would be a factor.
Okay. Because no business should rely on outdated cost numbers to justify current investment decisions. Would you agree?
Say that again, please.
No business should rely on outdated cost numbers to justify current investment decisions. Would you agree?
I think utilities or any business should use the best data that's accessible by them.
Okay, thank you. Mr. Fitter, I appreciate your time today. I don't have any more questions.
Thank you, sir.
Thank you, Mr. Hall. Commissioners, questions for this witness? Vice Chair Powers.
Thank you, Madam Chair. And good morning, Mr. Fetter.
Good morning, Commissioner.
First, I'd like to compliment you on your name of your business, Regulation Unfettered.
Thank you, Commissioner. I knew it had been established when people, the first 2 or 3 years I was in business, at every proceeding they said, does the name of your business means that you're totally for deregulation? And I had to explain that no, it is intended to explain regulation. And after 2 or 3 years, they stopped asking that question. That's when I knew it had been established.
Well, my last name being Powers, if I were to go into that sort of business, maybe you could help me come up with a catchy name too.
Yes, sir.
One thing that I've been looking at in your testimony, you talked about that the sharing of the costs from the coal ash compliance under federal and state standards in North Carolina, and you even said absent the CAMA law would make it required in South Carolina. What other North Carolina law is there, or what other North Carolina standard were you talking about other than CAMA?
I was just saying that steps, environmental steps that would need to be taken to allow the plants to continue providing service both to North Carolina and South Carolina customers should be fairly allocated among the customer bases.
Okay, and I still have a little problem with prudency. I mean, regardless of what's already been disallowed, there was a criminal action in North Carolina. There was admission, there was cost. Do you think South Carolina should have to bear any cost, or how do we determine what South Carolina's share is really my question.
Well, from listening to the hearing yesterday, the company made clear that none of the excessive cleanup costs from the Dan River event or the fines or the penalties are included within the case they filed here. So my understanding is that the company was seeking the necessary costs for environmental remediation and then a fair allocation. I think the fact that the settlement comes in at $83 million below what they were seeking might alleviate some of the issues that I've raised in my testimony, but I cannot be for sure.
Okay. The mention of the Allen steam scrubber cost, is any way that this should be distinguished in this rate case?
I was giving an example where state borders were not the deciding factor on what was a investment, a prudent investment made in the public interest.
Okay. You know, as a policy witness, and I think I've heard it over and over that about stable regulatory environments are a big factor or a necessary factor for credit ratings, even though we're dealing with monopolies. That argument always sounds like a little bit of fear-mongering to me.
It's not intended to be. I should note that the most difficult portion of the job of a bond rater or credit rater is dealing with the uncertainty surrounding future events, including regulatory decision-making. And so the more stable and predictable the regulatory environment, the better able is the credit rater to come to a judgment on the appropriate rating level.
Well, do you feel that with a good settlement with the parties have come up with, or that could be approved, or something at least in the range, do you think that's in any way is going to affect investor perspective or scare away money or have anything to do with that?
Settlements are prized because they lower the uncertainty. So credit raters welcome it for the lower level of uncertainty. Investors welcome it for the same reason. And I should say, as a chairman of the Michigan Commission, I welcomed a proposed settlement, and then we would put it through its paces, especially if a party was a non-signatory. And so I am foursquare in support of what you and the other commissioners are doing in testing out the concerns of DCA. At the same time, the existence of this proposed settlement, which included, I'd say, one of the most active parties on the other side, ORS, as well as, listening to Walmart today, where they are not objecting. I've probably been in dozens of cases where Walmart has participated, or a group representing industrial customers, of which Walmart was one of them. Walmart is knowledgeable and aggressive. And so the fact that they are not objecting is a very positive sign for this settlement.
All right. One non-relevant questioning. Do you miss being a commissioner?
I think being a commissioner was, in many ways, the best job I've ever had other than the compensation.
Agreed. Thank you very much.
Thank you, Chair.
Thank you, Vice Chair. I cannot see through your head. Commissioner Thomas?
Thank you, and good morning. It's probably pretty early where you are.
I got up at 3:30, and with the excitement, I had to be appearing today.
Well, I hope you're enjoying yourself.
So far.
All right, so basically I have a question about intergenerational rates. My understanding is that usually the customers that benefit from the power are the ones that should pay the cost associated with generating that power. And is that kind of a basic underlying principle to rates and regulation?
I think in many ways the goal is to match up costs and benefits. And so intergenerational equity should be a factor in rate making.
And so what I'm wondering is these plants have been in operation for a very long time. And the people that benefited from the power that was burned, that created the coal ash, that is costing money now, a lot of those customers are gone. And so a lot of money is being spent now that was benefiting the prior customers, not current customers. Any thoughts on that?
I saw in reviewing some of the outside documents cited by parties in this case, they talked about, with regard to nuclear plants, there's an ongoing collection of future costs and less so on coal ash. And so there's a bumping of heads, so to speak, between intergenerational equity and the fact that the life cycle costs of a coal plant may not be a perfect match. But that said, I still believe that prudent costs should be recovered by the utility, and maybe on a going forward basis, if something were to be put in place or a hearing would be held with regard to greater intergenerational equity with regard to environmental remediation, I think that might be a positive generic proceeding.
Okay. And so I guess basically another thought that I had is that let's just assume that a particular plant has been generating for 50 years and the expected useful life is, let's just say, another 25 years. And would it make any sense to say that that money that's being spent on the coal ash cleanup should be some of that allocated to the prior generation and some to the expected future generation, and the people that are going to be benefiting in the future, that portion of the expenses would be more appropriate to recover than money that's been spent?
Well, of course, reaching back to past customers would be impossible, and therefore, my comment about a potential generic hearing on how those costs could more fairly be assessed might be a positive proceeding in my view. So you get a greater balance, like you just described, Commissioner.
Okay, thank you. That's all I have.
Thank you.
Commissioners, questions for Mr. Fetter? No questions. Any redirect? I had to remember where I was. So.
That's fine. It's early. It's early for Mr. Fetter, too. My understanding he's on the West Coast, so glad he could be with us this morning. Mr. Fetter, I just want to ask you a few follow-ups from Mr. Hall's cross-examination. Let me first ask you were asked several questions this morning about the policy that you're presenting, the regulatory policy that you're presenting as part of your testimony in this case. Is it your opinion that a constructive regulatory environment is one that approves just and reasonable rates?
That provides just and reasonable rates, did you say?
Yes.
Yes.
Okay. And are settlements in a constructive regulatory environment, are settlements viewed positively?
As I said, very much so. You know, whether I was a regulator, a bond rater, an investor, or representing a utility, a commission, or a consumer advocate, a fair settlement is always a welcome thing in my eyes.
And is it important as a commissioner, as a bond rater, that when a settlement is presented, that if it is approved, that it's accepted as in total because it's a balance of interests between several parties?
Well, it's very much positive that a settlement not be modified, because depending on the modification, I think parties are free to walk away, and then the contested case starts up again. And so that's the potential fear of tweaking what had gone on behind closed doors.
Now, Mr. Fetter, you were asking questions about the regulatory compact, and I want to follow up on a few of those. First off, the regulatory compact, is recovery of prudently incurred costs fundamental to the regulatory compact?
That's, as I said, it's a touchstone in all my activities, beginning upon my appointment in 1987.
And under the regulatory compact, if costs are going to be disallowed because they are determined to be something other than prudent, is it important in terms of being a commissioner or a bond rater that there's evidence to support that determination?
Oh, well, not only evidence, but the more explicit the discussion can be by a commission as to why they found something to be imprudent, the better in all eyes. For instance, I don't think investors expect imprudent costs to be recovered. They are attempting to invest in utilities that have sound judgment and do not make imprudent decisions. They seek well-managed companies and hope that there's not a misstep that leads to imprudence.
Now, Mr. Fetter, DCA counsel pointed you to your response to witness board and DCA's witness, who you point out says explicitly that he did not provide an opinion on whether coal ash removal costs were prudently incurred, or an opinion on whether coal ash removal costs are required pursuant to federal law. Is that familiar?
That's what he said.
So let me ask you a couple of questions related to that. Now, are those two issues fundamental to whether a coal ash compliance cost in this case should be recovered?
Yes, an expert witness explaining why something was imprudent and the applicable law or regulation, I think, are key components of an imprudency finding and should be explained by the decision maker.
In your expert opinion, Mr. Fetter, would a witness challenging cost recovery of those items or a party challenging cost recovery, would they have done that type of evaluation to be able to make that challenge?
Yes, I don't see in the absence of such analysis how they can put forward a proposed partial or full disallowances.
Now, do you have Mr. Borden's testimony in front of you?
I might be able to find it, or do you want to just read something?
Yeah, let me ask you this, and I'm sure counsel will correct me if I'm incorrect about my citation. But on page 6 of Mr. Borden's testimony, lines 12 to 14,
I'm sorry to interrupt you, counsel. Do you mind if I get to that?
Sure.
Okay. Could you tell me again?
Page 6, lines 12 to 14.
Are you in direct? Direct?
Yes, it's his direct.
Thank you.
Counsel, I think I can find it if given a moment. Is this his direct or his rebuttal?
It's his direct.
And what page again?
Page 6, lines 12 to 14.
Okay, I'm at page 6, lines 12 to 14.
And you see there where, and I'm sorry, DCA counsel, are you, Mr. Hall, are you?
Yes,
there?
thank you. I appreciate it.
Do you see where Mr. Borden says to calculate a specific disallowance number requires extensive analysis that was beyond the scope of his engagement?
Yes, I see that.
Okay. Now, in your review of the docket, did DEC put forward an extensive analysis to support cost recovery for coal compliance, in your opinion?
I did not see such analysis from DCA.
Well, DEC, I'm sorry, the company. Did the company put forward?
Oh, I'm sorry.
Yeah.
Ask the question again.
Sure. Did the company put forward an extensive analysis to support cost recovery for coal ash compliance, in your opinion?
my understanding is that what witness Bednarsik was responsible to do.
Okay, and ORS witness Whitliff was the only witness that calculated disallowance, correct?
That is correct.
Okay. And with your extensive expertise as a former regulator, what do you take away from the fact that the two parties that did extensive analysis in this case have entered into a settlement agreement?
What struck me is that ORS was a bona fide contesting party, not only in this case, but in past cases. And the fact that it reached a comfort level with the proposed settlement would be very important to me as a regulatory decision maker.
Now, Mr. Fetter, you were asked some questions as well about intergenerational inequity by the commission. Do you recall those?
Yes.
Okay. And am I correct that in the life of a utility, there are generation resources in generally that are used and come in and out of service over a given life of a utility? Is that a fair assessment?
Yes.
Okay. And, you know, to the extent there are declining revenue requirements, a customer coming in South Carolina midway through a coal unit's life might be paying a little less than he might have paid if he was there at the very beginning of the coal unit's life, right?
Yes. Intergenerational equity can be a goal, but it cannot be assured just because of the way the utility industry operates.
And Duke Energy Carolinas has one of the largest nuclear fleets, I believe, in the country. Is that your understanding?
Yes.
And by the foresight of this commission and other commissions in the past who allowed those facilities to be built, customers are benefiting from that at a lower cost than what it would cost to build a new nuclear unit today. Would you agree with that?
Yes.
Okay. And to some extent, that may be an intergenerational inequity to our leadership and folks here who have lived here for years who paid early on, but now their children are benefiting. Is that fair?
I mean, clearly with plants coming in and out of service, as I said, intergenerational equity should be a goal, but cannot be assured just because of the nature of the utility industry.
And at the end of the day, is your understanding as a commissioner, a former commissioner, that utilities have to incur environmental compliance costs in order to serve their customers?
Madam Chair, I was letting it go a little bit, but I believe it's a continue with leading questions to his witness.
Do you believe that utility has to comply with the laws in order to service customers?
Without a doubt, they have to comply
Yes,
with all laws.
Okay. Thank
No, I was just saying it was a yes or no question.
you. Thank you, Chair Belzer. That's all the redirect.
Madam Chair, I do have one brief recross question based on his redirect.
Okay.
A new statement that's not anything from his prior.
We're gonna hear it. It's okay. Let's just we want to be right on this issue, so let us hear it. Thank you.
Hi, Mr. Fetter. Can you hear me again? It's Roger Hall, Department of Consumer Affairs.
I can hear you.
I want to just ask about one question. I didn't catch the full question, but essentially you had a statement that about settlements not being approved, and I believe your answer was that the parties could walk away and the regulatory process would start over again. Does that sound about right?
No, I said if the commission were to approve the settlement, but only with a certain modification, then I think the parties can choose not to accept the modification, and my understanding is the case would proceed.
Okay, I thought I had starts over again, but the case would proceed. Do you understand in South Carolina, the commission has 6 months to issue an order in this case from the time the application was filed?
I wasn't sure of that.
Okay, and so you're also not assured that wouldn't know that there are no provisions for continuing beyond that time period, right?
I'm not offering an opinion based on that procedural provision.
Okay, and so you would agree then, if that's the case, essentially one of the parties could appeal the decision, but that would be the extent of continuing the regulatory process, would be an appeal.
Chair,
Yeah, we're getting beyond that, and that's beyond more than one question too, so.
Apologize, Madam Chair. I'm pretty sure I heard something about the regulatory process starting over or continuing, and just wanted to clarify that
that's-
Mr. Feder is not
I
sure
did
how
not
the South
say-
Carolina law works.
That's,
If I can respond, Chair.
Mr. Feder, I think we're okay. That's for us to decide when if and when that happens, we're the ones that are gonna have to deal with that. Thank you, Mr. Hall.
Chair Belzer, I know it's at my risk and peril, but I just ask, now that Mr. Fetter's done his direct rebuttal, that he be.
I'm gonna tell him he can stand down. You can tell him whether or not he's excused. Mr. Feder, I know it's early. I appreciate the fact that you got up at 3 a.m. Believe me, I was awake at 3 a.m. this time thinking about this case. But thank you for your testimony today. It's nice to see you again, and we appreciate your testimony.
Chair Belzer, thank you. It's always a pleasure to appear before the South Carolina Commission.
Thank you. You're very kind. And I hope you have a good day. Thank you.
Thank you.
Who's next?
Chair, at this time, the company calls Brent Guyton and Bennett Fogg.
Let me do this. We've been going about an hour and a half. Why don't we go ahead and take a short break, because I have a feeling these two might take a little time. It is 10:41. Let's come back at 10:55. That gives us about 14 minutes. Thank you. Good morning and welcome back to the Public Service Commission as we continue in the hearing in docket numbers 2023-388E and 2023-403E. All commissioners participating are present. Recognize Duke Energy, Carolinas, Duke Energy Carolinas.
Good morning, Chair Belser and Commissioners. I'm Melissa New on behalf of the applicant, Duke Energy Carolinas. And at this time, I just wanted to clarify the panel will just be presenting their direct testimony and supporting the settlement, and they will be coming back on rebuttal.
Thank you, Ms. New.
Okay, Mr. Guyton, turning to you first, please state your name and business address for the record.
Brent Guyton, 555A, Asheville, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Carolinas, Director of Asset Management for Distribution.
And on January 4th of 2024, did you cause to be pre-filed in docket number 2023-388E direct testimony consisting of 37 pages?
Yes, I did.
Do you have any changes or additions you need to make to your pre-filed direct testimony?
No, I do not.
Okay, if I asked you the same questions here today, would your answers be the same?
They would.
Chair Belser, at this time, I move that the pre-filed direct testimony of Mr. Guyton be admitted into the record as if given orally from the stand.
Mr. Guyton's pre-filed direct testimony will be entered into the record as if given from the stand.
Thank you. Have you prepared or caused to be prepared under your supervision 12 exhibits labeled as Guyton Direct Exhibits 1 through 12 that were previously filed with the Commission as attachments to your pre-filed direct testimony in this docket?
Yes, I did.
Do you have any changes or additions to your exhibits?
No, I do not.
Chair Belser, at this time, I move that the Guyton Direct Exhibits 1 through 12 be marked and entered into the record.
Mr. Guyton's exhibits, which accompanied his pre-filed direct testimony and are marked as Exhibits 1 through 12, will be marked for identification and will be a composite exhibit marked for identification as Hearing Exhibit 23 and received into the evidence of this case.
All right, Mr. Fogg, turning to you next. Please state your name and business address for the record.
Bennett Fogg, 411 Fayetteville Street, Raleigh, North Carolina.
And by whom are you employed and in what capacity?
Duke Energy Progress, as General Manager of Transmission Engineering.
And on January 4th, 2024, did you cause to be pre-filed in docket number 2023-388E direct testimony consisting of 21 pages?
Yes.
And do you have any changes or additions to your pre-filed direct testimony you need to make today?
Yes, one modification. Page 16, line 19, change in Anderson to in the Anderson area.
Okay. And with those corrections, if I asked you the same questions here today, would your answers to your direct testimony be the same?
Yes.
Chair Belser, at this time, I move that the pre-filed direct testimony of Mr. Fogg be admitted into the record as if given orally from the stand.
Mr. Fogg's pre-filed direct testimony will be entered into the record as if given from the stand.
Mr. Fogg, have you prepared or caused to be prepared under your supervision one exhibit labeled as Fogg Direct Exhibit 1 that was previously filed with the Commission as an attachment to your pre-filed direct testimony in this docket?
Yes.
Do you have any changes or addition to your exhibit?
No.
Okay. Chair Belser, at this time, I move that Fogg Exhibit 1 be marked and entered into the record.
Fogg Exhibit 1, which accompanied Mr. Fogg's pre-filed direct testimony, will be marked for identification as Hearing Exhibit 24 and received into the evidence of this case.
Thank you. And Mr. Guyton, with respect to the distribution programs in the Grid Improvement Plan, on December 15th, 2023, in docket number 2023-403-E, which has been consolidated with this proceeding, did you prepare or cause to be prepared Exhibits A and B to the company's petition to extend accounting order to continue regulatory asset treatment for ongoing Grid Improvement Plan costs?
Yes, I did.
And similarly, Mr. Fogg, with respect to the transmission programs in the Grid Improvement Plan, on December 15, 2023, in docket number 2023-403-E, Did you also prepare or cause to be pre-filed Exhibits A and B to the petition to extend the accounting order?
Yes.
And gentlemen, starting with Mr. Guyton, do you have any changes you need to make to those exhibits?
No, I do not.
Mr. Fogg?
No.
All right, Chair Belser, at this time, I move that Exhibits A and B to the company's petition to extend the accounting order in docket number 2023-403E be marked and entered into the record.
Excuse me just a second here. Exhibits A and B that accompanied the petition in docket 2023-403E will be a composite exhibit marked for identification as hearing exhibit 25 and admitted into the evidence of this case.
Thank you. And gentlemen, starting with Mr. Guyton, while you did not file settlement supporting testimony, do you support the stipulation as a fair and reasonable compromise, resulting in just and reasonable rates in the public interest and should therefore be approved?
I do.
And Mr. Fogg?
I do.
And gentlemen, have you prepared summaries of your direct testimony?
Yes.
Would you please provide the summaries of your testimony, starting with Mr. Guyton, please?
Ms. New, do y'all have copies of those summaries?
We do.
I don't think those have been distributed, have they? My bad, sorry.
Okay, Mr. Guyton, you may go ahead.
Certainly. Chair Belzer and members of the commission, I am the Director, Asset Management and Customer Delivery for Duke Energy Carolinas, LLC, which I will refer to as DEC, or the company. I am responsible for planning for the grid and related system improvement efforts by DEC to build a smart thinking grid capable of integrating dynamic energy resources while providing increasingly safe, secure, and reliable energy. In my direct testimony in this proceeding, I describe and support the existing DEC distribution system, the operation and performance of the distribution system, and the costs necessary to operate and maintain it. More specifically, I explain that as part of the company's commitment to reliably serve its customers and continually improve operations, DEC has invested approximately $1.2 billion in electric plant in service for distribution infrastructure in South Carolina since its last rate case. I also detail grid improvement plan work completed since the company's last rate case, and I explain how it is helping improve the resiliency of the grid. DEC's grid improvement plan is built upon strategic, data-driven investments targeted to avoid outages and speed restoration, harden the grid to protect against cyber and physical threats, expand solar and other innovative technologies across a two-way smart thinking grid, and give customers more options and control over their energy use and tools to save money. I describe how these investments work to protect the grid through compliance-driven programs, modernize the grid through programs that leverage advanced technologies, and optimize the customer's experience. As part of the settlement agreement reached in this case with the settling parties, we have agreed to discontinue the deferral of the grid improvement plan, but include the associated construction work in progress costs in rate base. Notably, as part of the stipulation, even though none of the other parties except for the Department of Consumer Affairs recommended a disallowance of the company's targeted undergrounding costs, the company has agreed to a disallowance of $2.5 million of these costs. And the company has agreed to this provision despite the fact that the Department of Consumer Affairs is the only party not joining in the stipulation. We have also agreed to update system-level reliability reporting to include, in addition to System Average Interruption Frequency Index, or SAIFI, and System Average Interruption Duration Index, SAIDI, metrics. Customers experiencing multiple interruptions, SIMI 4 and SIMI 8, and customers experiencing long duration interruptions, CLID 6, metric reporting. The company also agrees to work with stakeholders to evaluate the timeline and cost estimate attributed to applying the reliability reporting metrics to census tract and zip code levels before the next general rate proceeding. In this effort, the company will take steps to minimize any costs associated with this additional reporting. Provided the evaluation shows it is feasible and costs are reasonable, the company agrees to update its reporting to include these 5 metrics at both the census tract and zip code levels on a timeline agreed upon by stakeholders. If cost estimates are unreasonably high, the company will work with stakeholders to evaluate cost reduction opportunities. Finally, with regard to vegetation management, the company agrees with reporting requirements that are consistent with the manner in which Duke Energy Progress, LLC reports its similar efforts. This concludes the summary of my direct testimony.
Go ahead, Mr. Fogg.
Chair Belzer and members of the commission, my name is Bennett Fogg. I am the General Manager of Transmission Engineering for Duke Energy Progress, LLC, an affiliate of Duke Energy Carolinas, LLC, which I refer to as DEC or the company. I'm responsible for the engineering design of transmission lines, substations, and associated systems for the Duke Energy Progress service territory. In my direct testimony in this proceeding, I describe and support the existing DEC transmission system, the operation and performance of the transmission system, and the investments necessary to operate and maintain it. More specifically, my testimony explains that as part of the company's commitment to reliably serve its customers and continually improve operations, DEC has invested approximately $1.8 billion in electric plant in service for transmission infrastructure across the DEC system over the past 5 years since the company's last rate case. I also detail the transmission-related grid investments and grid improvement plan work completed through 2023. My direct testimony provides an overview of the management and organization of DEC's transmission grid, and I explain that our grid is managed by coordinating operations, maintenance, and planning activities across the DEC service area. Since the company's last rate case, we have made targeted investments in the company's transmission system to provide capacity to serve system growth, ensure adequate system voltage, support transmission-related infrastructure for the addition and decommissioning of generation, and improve system reliability. I describe the metrics we use to assess the effectiveness of our transmission operations, and I report that DEC has performed well as compared to its industry peers, especially with regard to customer outage duration. I explain how our transmission integrated vegetation management program is focused on ensuring safe and reliable system operation. We focus on the removal and/or control of incompatible vegetation within and along the right-of-way to minimize vegetation-related interruptions and maintain adequate conductor-to-vegetation clearances, all while ensuring compliance with regulatory, environmental, and safety requirements and standards. My direct testimony, along with the direct testimony of company witness Guyton, also supports the transmission investments made through the Grid Improvement Plan. I also detail the operational benefits of transmission's hardening and resiliency sub-programs and describe how they each address unique challenges to harden DEC's system and minimize the impacts of disruptive and unplanned outages to customers. As part of the settlement agreement reached in this case with the settling parties, we have agreed to discontinue the deferral of the Grid Improvement Plan, reporting requirements for vegetation management that are consistent with the manner in which Duke Energy Progress, LLC reports its similar efforts, and other provisions. This concludes the summary of my testimony.
Thank you, gentlemen. Chair Belzer, at this time, the panel is available for cross-examination from the other parties and questioning by the commission.
Thank you, Ms. New. Mr. Hall or Mr. Edwards?
Similar to what we've done with the other witnesses that are split, we'll reserve our questioning until their rebuttal is put in the record.
Thank you. Commissioners, questions? Commissioner Carolee Williams?
Thank you, Chair Belzer. Gentlemen, thank you for being here. I'm going to ask both of you the questions, and you can answer me as your expertise allows you to do it. There was discussion, and this is just purely your curiosity, about vehicles and reliability, and could you describe more of what that circumstance is?
Certainly, I'll start this one. So, and this is mainly a distribution impact. There may be some in transmission, but this is really a distribution impact. So, in my direct testimony, you will see the trends for both SAIDI and SAFE. They both have inclining trends, which means lesser performance, worsening performance in that space. This certainly was a concern for us as a company when we saw that. We've seen this similarly in other jurisdictions, including DEC North Carolina, so this is not unique to DEC South Carolina. What we've seen is there, over the 5-year historical average of public vehicle accidents, so that's vehicles striking poles adjacent to the roadway, as well as hotline tags, and I can explain what the hotline tags are as well. It's critically important because it's where we're doing great work for the customers, but there's a safety factor for the line workers, and I'll explain more about that. But the public vehicle accidents, we saw this really pick up when the pandemic started. And I would say, this is my opinion, this is not a national traffic study. Distracted driving is what happens when people leave the roadway typically. There could be a medical emergency or something like that, but typically it's distracted driving, whether it be chemical impairment or distracted driving with devices or other things. For whatever reason, whether it was people not being at work, more people on the road, other activities, we saw that spike in 2020, shortly after the pandemic started. We expected to see that tail back off as we came through the pandemic and, you know, the work life, et cetera, returned to whatever the new normal is. Really haven't seen that. It has reduced slightly, but it still remains elevated. My opinion is it's still distracted driving. The rental car that I have to be here, everything has a touch screen in the dash now. Some of them are very large, et cetera. And most folks now have a smartphone in their pocket that is probably not in their pocket when they're driving. So for that, and I don't know what the statistics are on impaired driving, but we have not seen that pare down. So that's a big driver. One of the things that we're doing to address that, and we recognize that as we work through our planning processes, and this started a couple of years ago when we saw this during the pandemic, is look for ways where we see repeat impacts in certain areas. It may not be the exact same pole or facility, but somewhere in a zone, and look, is there a solution where we can make adjustments to our facilities to remove them from the typical path that a car would leave the roadway. And a simple example might be our overhead facilities are along the outside of a curve. Maybe the impacts tend to be where they leave the road to the outside. Maybe there's an opportunity to move them to the inside in that case, or other alternatives, including undergrounding if that makes sense. So we do have a program that looks at that. It's part of our hardening and resiliency work that we describe in the grid improvement plan. So does that help with the public accident piece?
That does. And so it's not at all related to age of pole, condition of pole.
No, ma'am. We do inspections on poles for strength, and that's part of our infrastructure or integrity and maintenance work. If you saw that in my pie chart in direct testimony, that's where we do pole replacements based on a strength assessment from that. But a multi-ton vehicle at X miles per hour is, no matter if it's a brand new pole, it's coming down.
And my next question, you heard a preliminary to it yesterday, and that is related to vegetation. Just wondering about new opportunities to be able to inspect, plan for, understand what's happening in the field without having to be in the field, or to help you not have to be in the field as much, or be able to service more often.
I'll take this one to start with as well.
Okay.
So currently, as we do vegetation management, there are multiple parts to our integrated vegetation management plan. So one of those is what we call cycle trimming or production trimming, where we have the tree study information that informs the cycle that we should come back. And when we do that, we start at the breaker in the substation and trim the entire mainline backbone as well as all the tap lines or laterals that have vegetation that needs to be trimmed. And that's informed by that. That's been our historical method that we've used to date. We are actually in the process of evaluating satellite imagery to be able to see what the vegetation is, build that with models and machine learning into, hey, here's the outage history for this. And this is an important part. So rather than looking at the entire circuit based on its 5 years or 7 years since it was trimmed, well, let me go back to the integrated. So besides the cycle trimming, we also do reactive trimming. That's part of our vegetation management. So when you have a particular species on that circuit that may be growing faster, maybe causing issues, our reliability techs will look at that, maybe based on either customer complaints or data they've seen, and would send a crew out there to do the term in the field is hotspot trimming, but it's reactive trimming based on that. So that's another piece of that. I can go into the other parts, but I'll pause with that. But where we're moving to is the term is corridors rather than circuits. Corridors essentially equate to a protective device. So if you think about a distribution circuit from the substation out, and I'll use this analogy, roadway analogy. Transmission is the interstate highway system. Distribution circuits really have two main categories of circuit. It's the main line, backbone part of the circuit, and then the tap lines, laterals that we have. Think of the main line as a urban or suburban multi-lane boulevard. And then think of the tap lines or laterals as all the little streets that go off to the side into neighborhoods, business parks, wherever they may go. Every time there's a branch on a circuit, there's essentially a protective device. We segment to minimize the impact of a fault event wherever it occurs on a circuit and minimize where, which customers are impacted. This new concept by satellite imagery will actually look at the individual corridors or pieces of the circuit down to the protective device. So instead of a circuit being one entity that we trim on a cycle, there may be hundreds of pieces of the circuit that, based on satellite imagery, will prioritize when that needs to be trimmed. Now, that may seem inefficient. Hey, you're going to send a crew here to do this little piece and do this little piece. We will cluster those together and actually bid those out. Here's a 2025 work plan. Here's a 2026 work plan. And those contractors would then bid on those clusters in a geographic area. But they wouldn't necessarily trim every corridor or piece of a circuit. It would be what's needed from that perspective. That essentially aligns us more with what transmission's been able to do with LiDAR. Now, this is different technology, but the same concept, leveraging technology to not be more manual cycle or folks in the field looking at that. So I'll pause there unless there's other questions about that.
I can speak on that a little bit more from the transmission perspective.
Okay.
So we do have a 10-year normal maintenance cycle. You mentioned that yesterday during your questions, but we also supplement that with a 3-year herbicide cycle. So we perform herbicide spraying every 3 years. That's also supplemented as part of our integrated vegetation management program with our reactive work. And part of that reactive work, as Witness Guyton mentioned, we perform LiDAR, which is remote sensing. Using light pulse. And so what that does is it maps an image of whatever, trees, vegetation, and it gives you ability to see what the clearances are. And as part of our reactive program, if we find that clearances are violated, we'll go out and perform maintenance there. So it supplements the programs that we already have. And so we can perform using that as well as some other aerial patrols that we perform. So there's a number of things that we perform that will help supplement our program so that we can perform reactive work, and we're not just waiting every 10 years to make sure that lines are cleared. We're performing that work as we see it and as the conditions present themselves.
That's very helpful and informative. One of the notes that I read in Ms. Hunsinger's memo had to do with what I thought was a private property tree. And it may not have been. It wasn't clear, but from the presentation that was made in one of the customer public hearings. So my question is not about that individual situation, but just in general. How do you decide when to address a tree on private property and when you don't? When is it the customer's responsibility and when is it not?
Yeah. So we are able to analyze danger trees and hazard trees. So danger trees are trees that are at a height that will threaten the transmission system if they were to fall over. And so we have a program that will remove the danger trees on private property, notifying the customers as we can to be able to ensure that we can still provide reliable power because they're a threat. We also analyze hazard trees. Hazard trees are a little bit different than danger trees. Hazard trees are trees that don't have good health. And so we aggressively go after those and remove those. So in terms of, we will remove danger trees within the right-of-way and a certain footage outside of the right-of-way, 16 or so foot, just depending on what type of maintenance that we're doing. So as we analyze these trees and we come across them, we'll remove them and talk to the customers and just to make, or we'll notify the customers just to make sure that they're aware because we do have the ability to move those within a certain distance there. So we'll notify them and to make them aware that we're removing those trees. And so it's part of our program to assess to ensure that we can make sure that those trees are not going to fall over in the event of or whatever event and affect our reliability.
Commissioner, may I ask a question about that?
Sure.
Mr. Fogg, when you say that y'all have the ability to go outside the right-of-way like 16 feet or so, is that because of NERC standards? Or what? What gives y'all the ability to go outside of that right-of-way?
Typically, we do have easement-type agreements
Okay,
to
but
be
it's
able to
within the
perform.
easement?
Yes, within the easement.
Okay. Because I can imagine people getting upset if you're outside and you're cutting their tree.
Within the
That's why
easement, right, not necessarily on the private property
Okay.
of customers.
Thank you for that clarification.
So I was going to ask something related to that, thinking that you were talking about private property. What gave you the authority to do that and just notify the customer as opposed to get the customer's input?
That's a great clarification, within the easement, not,
Okay.
not
You
on
weren't-
a
you
customer's,
weren't
we're not, that's right, we're not going directly on a customer's private property.
So if you were on a customer's private property, you would get their approval?
Yes.
Okay.
So for distribution, very similarly, what I'll describe is this is another part of the integrated vegetation management plan. And distribution calls it hazard tree assessments, very similar. We don't have what we call danger trees specifically. What we're looking at is hazard trees. These are outside the right-of-way, private property, not within the easement that we have. We maintain our corridor trim within the easement that we have. What we do in this case is there's both a level 2 assessment, which is actually a walking assessment by a arborist to look at trees. And we were looking for dead, diseased, dying, otherwise structurally unsound trees that could fall into the right-of-way and damage facilities. Once those are identified, we also do, if we're doing production trimming, they'll ride the entire circuit looking for those, but it's more of a ride-along type assessment, so not quite as intense as the walking. Once those are identified, though, because they are on private property, we will contact the customer and say, we have identified this tree. Here's the issue with it from a health perspective, answer any of their questions, and we ask permission to take that tree down from that perspective. If they refuse, we leave the tree. But we make every effort to convince them, let us take it down from that perspective. There are cases where it may be in a very rural area. We'll make every attempt, and there's not a home or something on the property at that spaces. We'll attempt by property records and to contact those property owners after attempts for that. If we get no response for those, if it is an imminent hazard, we will take those down. If it's not an imminent hazard, we leave those, and hopefully we can make contact later for those as well from that. And the reason for that, from a distribution perspective, this is likely true for transmission. When we have vegetation contact distribution lines and it's from really inside the right-of-way, it tends to be limbs or dead limbs falling out of trees. They can still cause outages. They typically don't cause structural damage to our facilities. When you have tons of wood crashing into the right-of-way, we end up with broken poles, broken conductors. It is heavy infrastructure work to rebuild that when you've got that kind of mass falling into the right-of-way. So that's the reason we take those down and pursue those with customers. Those are very impactful. About, just as a data point, about 25% of the outages we see on distribution are vegetation related. Usually, plus or minus a couple of points, 50% of those are from outside the right-of-way fall-ins, and 50% are from inside the right-of-way. So it's very impactful to be able to grab those, to take those trees down proactively.
That's been very enlightening. Thank you. I may have one other question, but I need to really put my mind back into it while someone else asks you questions. So thank you.
Mr. Guyton and Mr. Fogg, I have a follow-up, and this just goes from having handled consumer complaints in my previous lives, but when your folks go out and do this trimming and taking down of limbs and trees, do they haul off the wood or do they leave it there for the customer? I mean, it depends. I know we've had I've dealt with consumer complaints complaining that stuff was left for them to clean up or complaining that it wasn't. So I'm just curious as to what the norm is.
Absolutely. So I'll give the distribution version. So there's two categories and a subcategory, and I'll explain. So in storm situations, we remove the hazard so the crews can restore. We do not haul away anything, maintained yards or unmaintained. It's restoration. When we're doing our trimming, whether it be hazard tree removal or our maintenance trimming, in maintained areas, we chip the brush and take that away from that perspective and clean it up. Unmaintained areas, they will, do this from memory subject check, they will chip the brush, but I believe they leave the wood, the mass of the tree from that perspective. When we do hazard trees, very much the same thing. We will take the tree down safely, cut it into pieces where the customers can use it for firewood or whatever they may do. We still chip the brush, but we leave the trunk of the tree or the larger pieces now from that perspective.
And my understanding is that Transmission does the same that witness got described in terms of maintained and unmaintained areas. There's a lot of maintained corridors that don't necessarily affect customers. So in those cases, we wouldn't necessarily remove all of it. We remove a good portion of it.
Thank you. Commissioner Caston?
Thank you, Madam Chair. Good morning.
Good morning.
Good morning.
Mr. Guyton, these are probably more for you. Relative to I think the acronym y'all pronounce CEMI, C-E-M-I?
Yes, sir.
CEMI 4 and 8 and CELID 6. And in item 43 of the proposed settlement, it's discussed, and company may seek recovery. Company will take steps to minimize any costs associated with this additional report, providing the evaluation shows it is feasible and cost are reasonable. And I think in your testimony just now too, you said that there would be every effort to work with stakeholders to get this done by the next rate case, whenever that is. That was 30-second synopsis, but is that generally?
Yes, sir. That's my understanding from reading the settlement item.
All right. And were you present yesterday? Were you able to hear any of Ms. Hunsicker's discussion? And
Yes, I was. I was here the entire hearing.
And not trying to put words in her mouth, but it was my general understanding, I believe the way she described it was the Customer Connect system in concert with the AMI, SAP, and the other business systems, you know, having the ability, among other things, to provide the company the ability to identify and evaluate customer usage patterns, outages, length of outages, and so on.
That is true, but with a clarification. To my knowledge, and I'm not a Customer Connect expert, so I would defer to Ms. Witness Hunsicker on this. Our official record of outages is our outage management system. That is where all the data that we provide reports to regulatory and commission comes from our outage management system. That is not part of Customer Connect. What we are able to leverage is our AMI system, and she did describe this, where we can see if an individual meter has power or not. We use that during major storm restorations to see where outages are. As we're performing cleanup, we're finishing the outages, or we're finishing up the storm restoration. We brought a big circuit back on with 3,000 customers. We'll ping all those meters to see, is every meter coming back energized, or is there some problem way down on that circuit that we need to go address briefly? So I don't know if that helps, but there's a separation between Customer Connect and our official outage management system, what we use in storms and operations to restore power.
Well, you actually just answered my second question.
Okay.
The outage management system, which I didn't know that was not interfaced with the other business systems.
There is some interface, but just we don't leverage Customer Connect for outage data, reporting, dispatching crews to do restoration.
Well, the question that I was going to ask that you answered was, any customer that has an AMI meter, that data, whether it's on or off, how long it was off, is there and in that system.
That is my understanding. It records on off in the records, and when we pull back usage data, et cetera, I think those on off records come back with that as well. But again, we don't leverage that for official reporting. We do leverage some of the on off timestamps to correct our outage data. In other words, if the OMS system predicted that the power went off at 10 p.m. and we could see from OMS data it was 10:05 or 9:55, we'll actually correct the outage data based on those AMI timestamps. So we leverage that for very specific granular data scrubbing and cleanup, which we never had that opportunity to do before. All we had was outage management system. We had to base that on customer calls, et cetera, but now we can leverage the AMI data for that.
You're pre-answering a lot of my questions, which is just fine. But with that, what did you call it, your outage? What?
OMS, outage management system.
OMS. And you're saying there is some interface with the other business systems, including Customer Connect, but you do not know, or you do know that all the data isn't available. Is that an accurate statement?
Can you repeat that?
Here's what I'm trying to determine. Would it make sense for the OMS system, whatever information, data is available in it that could be useful for planning, doing whatever, would it make sense for that information and data to be accessible or usable via the Customer Connect or whatever system it is that, here's my point, and I'll let you answer that question. My experience was data is nothing but taking up space unless I can use it. And I can't use it unless I have it and I have the systems in place to mine that data. Would it make sense for the OMS to have data that could be mined via the other business systems, whether that's Customer Connect or what?
So while not an expert in this, I believe they actually do. And so I'll give you an example, and this may relate back to what Witness Hunsicker was talking about. I do believe that agents in the call center, if a customer calls and they're have a concern about reliability or outages, I do believe they're able to query the outage management system and see that customer's actual outage history. I don't know what period of time frame they can pull, but they can do that. What they're not allowed, what those call agents are not allowed to do is they don't have the ability to make any updates. They're a view only. They can't actively work in the OMS system. That's reserved for the control center operators and others. But they do have a viewing portal into that. That's the really cool thing about Customer Connect is it enabled on the customer service side linkages to those types of data that they could not get before, or they had to, I'm talking to the customer using this system, I got to go over here and open this system up and try and pull some data, in this. I think it's very integrated now. I have not spent time sitting in a call center seat, but that's my understanding. And we're certainly doing that in operations space. So in the control centers, I mentioned the outage management system. That used to be a standalone system that if I'm an operator, I've got one screen with the OMS system and it's Oracle or something, and I've got my distribution management system, which may be, I don't know, I'm trying to think of another vendor, and I'm operating in two different systems. The advanced DMS system has integrated OMS, SCADA, and the DMS system all in one platform, and that's been rolled out across the enterprise. So that's the kind of integration we're doing on the operational side. I think Customer Connect brings those advanced capabilities to call center folks, and there's also ways to build bridges and linkages one way and two way between those operational systems and business systems.
Well, it at least to me, it certainly reads like from the testimony and hearing the testimony of Ms. Hunsucker and you and others, that there certainly seems to be a capability to really use data that's available throughout the system to better manage function.
Absolutely.
Always my dream. Never could quite get there. But it sounds like Duke Company in general, DEC in this case, is closer to that, if not there.
Yes, sir.
With that thought in mind, and again, not trying to paint you in a corner, trap here, but when I was reading some of those things in that item 43, if it's not cost prohibitive, we ought to be able to do this by the next rate case. And I'm not trying to simplify this. I know it's always more complex. I know that. But with these incredible systems that you guys have, and if wherever you have an AMI meter in particular, and with all this data that's sitting there and available, it seems like if I ask you, Mr. Guyton, can y'all get me this semi-six sealant and all this stuff by tomorrow at noon, you could do it. It really does.
Yeah.
Now, I'm not saying that's the case, and I'm not saying it's that remote, but it just seems to me, based on everything I've heard, read, that you really covered, and hey, it's y'all's proposed settlement. I understand it. I would want to make sure everything's covered too. I believe you really covered your bases on that one. My gut tells me, based on all the information I've heard, you can really do all that a lot quicker with minimal cost, but you guys have to determine that.
So I've had some high-level conversations with some of our reporting folks that would be part of creating this, as well as the GIS system as well. And my operational understanding, so I'm not an IT or reporting expert either, so I'll give you my version of it, my understanding. I think anything is doable. It's just how long it takes and how much effort, and usually time equates to money and resources, et cetera. So that's really what's happening here. Certainly, I think census tract and zip code layers that you could import into a GIS system, I'm assuming those files exist. I have no idea what format or whatever, but I'm assuming we could add that as a layer in our GIS system. I think that's the easy part. I think the more difficult part is, and I'll give you an example. I think the more difficult part is our system is based on protective devices. It's a fuse, it's a recloser, it's some device that will operate, and we know which customers are downstream of that. So if that device operates, those folks have had a momentary outage or a sustained outage. The challenge I see is that protective device may sit in one zip code, and the 1,000 customers behind it, or half the 1,000 customers, might be in another zip code or census tract. And so I think the challenge will be, we've got to actually, I guess we have customer information with their zip code. I'm not aware that we have customers aligned to census tract. So I think we'd have to have some kind of data point that says, Mr. Guyton's house is in this census tract in this zip code, and the protected device, no matter where it is, if there's an outage, we have to know which of those geographic areas he sits in to say, what's the performance for that individual customer. I think that's the bigger challenge. And then you have to build the reporting that would run batches, et cetera, and provide the data at whatever the point is. So that's my limited understanding from some high-level conversation. I have no idea what that takes as far as man hours and system integrations and things of that nature.
Well, from question conversation, with Mr. Duncan yesterday, as I recall, it appeared to me, or at least in my opinion, that whether it's zip code, census tracts, or whatever, that whatever the best way to do it, whatever is a more appropriate way, whatever makes sense or more sense, would most likely occur through the collaborative that exists. Right. And as I told you before, I suspect it's more complicated than I'm saying, because, I had many visions, many great visions or ideas in my previous life. And I tended to oversimplify everything and let other people complicate them for me. So I fully expect that on this. All that said, it appears to me still, you guys have all the systems in place, really good systems, really good people. And somehow I just have faith that you guys are going to be able to do this at a minimal cost pretty doggone quick. But time will tell. It's been very helpful.
Thank you.
Good information, and I appreciate it.
Certainly.
Thank you, sir.
Thank you.
Commissioner Thomas.
Thank you, and good morning.
Good morning.
Good morning.
So I have a question. This is probably more to you, Mr. Guyton, and this relates to some things that we heard at the customer public hearings. And I remember hearing from one customer, and she was talking about tree trimming, and I can't remember whether the tree was inside the right-of-way or outside the right-of-way, but the problem that she was having or perceived is that the tree was trimmed, is all trimmed on one side, and it's kind of leaning towards her house and too close to her house, and she just didn't feel real comfortable about how that was resolved. And I'm just wondering, I've seen trees that look pretty dangerous because they have been trimmed on one side, and how do you resolve that one, for a customer when that kind of a situation arises?
So I'm looking at my notes here. I remember the one that you were talking about. I want to make sure I have the right one. I believe this was Mrs. Betty Melton in Lancaster.
Sounds about right.
And so here's what I was able to determine. We talked to operational folks to understand what happened, and I'll give you the short story. And if you need more details or have more questions, happy to give you. This was actually and I've dug into this because we weren't sure if witness Fogg would be attending, so I was doing this so I could represent this to you all, expecting questions on this. It actually was part of a transmission, the Monroe line. It's a 100 kV circuit. They were doing a rebuild on that line. Is the situation with this particular customer. When transmission's doing a rebuild, they certainly are assessing the right of way. Their scope and the reason they're there is to rebuild the physical infrastructure of the line itself. But while they're there, this is not part of their major scope. They're gonna look at any impacts in the right of way. This right of way, I believe, was 68 feet wide. Is that Monroe 100 kV line? For the trees in Miss Melton's yard, they were actually outside the right of way, so not within that 68 feet right of way. And in the past, they had been trimmed to maintain the corridor appropriately in clearance from the transmission conductors. So the project team, their scope and their mission by leadership was rebuild this 100 kV line and get any right-of-way clearance you need within the right-of-way. That's what they proposed to Mrs. Melton. She preferred the trees taken down. I don't know her reasonings, et cetera. That particular person that was part of that veg crew supporting the transmission rebuild didn't have the authority to do that. That was beyond the scope of what they were permitted to do. After hearing her complaint, there was a leader in the vegetation management team went out and met with Ms. Melton to assess it physically in the field. And what they were able to determine, and it's very unusual to have a customer ask you to take a tree down. They usually don't even want you to trim it, let alone take the tree down. As the supervisor looked at that, I don't know the height of these trees, but essentially we were able to, because she wanted them removed, we were able to remove a fall-in risk. You heard Witness Fogg talk about fall-ins from danger trees and hazard trees. While that crew, they were there, they were able to take those 2 trees down and permanently eliminate a fall-in, and they verified they would have hit that 100 kV line if they'd fallen in at the right of way. So I don't know how many customers, I don't know if Witness Fogg knows, are served by a 100 kV transmission line, but it is thousands of customers that are served by that line. So that's actually the situation that occurred there. It was a win-win. We were able to remove the trees, eliminate that hazard, and that was something that Ms. Melton was willing to let us do.
All right, appreciate it. Thank you.
Mr. Guyton, may I follow up on that just a little bit?
Absolutely.
I understand that the company has the ability and really the requirement to remove trees that present hazards or to their lines. But where is the trade-off that customers who want their trees removed, and it really should be their responsibility, they just don't want to pay for it? I mean, there is a line there because the company and other ratepayers don't need to be paying for somebody that just doesn't want to pay to have their tree taken down.
Absolutely. This one was, if those trees, the simple example I would give is if those trees were not fall-in risks, no matter how much Mrs. Melton wanted them removed and she was worried about her house, we would not have done that.
Okay.
We would have simply, the minimum or maximum we would have done would be trimmed to maintain the right-of-way. That would have been it. But the fact that they were tall enough to be a fall-in risk, we were able to permanently eliminate that fall-in risk in the transmission corridor.
I mean, I'm sure the company is cognizant of that, but I mean, I know that there are folks out there that don't want to maintain their own, and they'd rather y'all do it for them. But
we run into that.
But I'm sure the other customers shouldn't have to pay for that. Is all I'm
absolutely, and that's one of the things we train our folks on is understanding how customers pay for that, and that's why we can't do it.
Okay, thank you.
You're welcome.
Vice Chair Powers.
Thank you, Madam Chair. Mr. Fogg, it's your turn.
All right.
I was looking at your chart and looking at your direct testimony, and your exhibit is for the whole South Carolina system. And in your testimony, I think I'm on page 4, line 14, you go through that, you're showing us the whole Duke Energy project, the however many $1 billion it is. Why not a separate exhibit that shows South Carolina specific information? I think you stated that it's, it's important for us to see and understand the whole system. I don't care about the whole system. I need to know about South Carolina. Why is there not a separate exhibit for South Carolina?
Yeah, the system is very integrated. So there are impacts from across the transmission system that do impact South Carolina, especially on the transmission system. An outage on one line could cause loading on multiple lines around the area. So the way we look at the system is we have to invest in programs in the company across the system. That's part of the reason we look at the system in whole. But you reference page 4.
That's what's so scary is that we're looking at stuff on a system-wide basis. We want to know what our South Carolina's retail portion is.
So
what are we getting? What are we paying for? And that's just hard for me to understand. Maybe I'm in a fog instead of your name. I mean, it's just that really is hard to understand.
I understand. So we invested $1.8 billion DEC across the system. And so if you look at, in terms of the grid improvement plan work that we did, $613 million of that was for DEC. We can break that down further to South Carolina through 2023, $111 million of that was for South Carolina. So that's not demonstrated in the chart here, but those are further numbers that identify the approximately 658,000 customers that were impacted by the work that we did in South Carolina.
Okay. And you feel that that's the fair number? I mean, I guess I would need to look at some of the accounting sort of things that would not be the things you're doing a testifying about to make sure it's a fair number.
I do. The way that we select programs, we go by the need. So when there is an issue that comes up and we see that the infrastructure needs to be modified, we need reliability improvements here and there, we select our programs based on that, and that's how we prioritize. So the work that we've prioritized as part of this program in South Carolina was most certainly needed, and that's the number that it came out to in terms of the cost that we spent there, in comparison to the total cost.
I guess
of the work
there was a statement somewhere that all transmission facilities are used and useful for South Carolina. And you're talking about the whole program, and that just reminded me of before your time, the old trickle-down economic theories that, if everybody at top gets something, maybe I'll get a breadcrumb sort of thing. But the numbers are tough to understand. That's the point I wanted to make. Did you talk about the adjustments and component subparts and the reasonability of, I think it's adjustment 2160. Is that in your testimony, or is that somebody, is that in Ms. Jiggett's?
Adjustment 21, I'm not familiar with that.
Okay.
If you have a reference, I could maybe follow along with it.
I got so many references.
Adjustment 2160 does not ring a bell with me.
Okay, that's fine. One second. That would be all I have. I just got more studying to do.
Commissioner Carolyn Williams.
Thank you, Chair Belzer. I appreciate being able to take a break and come back with a few more questions. I want to talk about reliability in general and SAIDI and SAFE and what customers can expect. And so let's start with how do Duke Energy Carolina's SAIDI SAFE numbers relate to the Southeast? And we talked some about vehicles and that impact. I'd also be curious how much does that translate? Is that from a reliability perspective, is that a significant portion of the issues that we're having, or are the issues coming from other places?
So SAIDI and SAFE are really distribution metrics. OMI would be a transmission reliability.
Okay.
So let me take those. So I would say that vehicle accidents have always been, part of the events that we have to deal with that cause outages. The reason that we're pointing to those is we're seeing, as I stated earlier, it's well above the 5-year average. They certainly vary by year from that perspective, just like weather does from that. As I stated in my direct testimony, we're seeing worsening trends in SAIDI and safety. We understand, and the reasons I talk about the public accidents and hotline tags is we understand what the drivers are. We also have, there's a third piece that I did not have in my direct, but near MEDs. So you heard, I believe it was Witness major event days.
Okay,
Witness Duncan, I believe yesterday there was some questions, or he was describing that we tend to exclude major event days to normalize the data. We still have data including major event days. A third thing that we've seen impacting this, and this is not unique just to DEC South Carolina, we see this as well, but what an MED is, there's an IEEE calculation that says if your daily SAIDI exceeds a certain value, that's when you exclude that data from reporting, or you segment it out. Here's your non-MED data, here's your MED data. What we've seen also, and this is one of the mega trends we described as a reason for a lot of the grid improvement plan work, is more frequent and severe storms. That's not just the true hurricanes or major winter storms, et cetera, that drive a major event day. We see more active and frequent intense thunderstorms that may not trigger an MED. And I've seen data that actually shows that when we have a higher than normal level of near MEDs, and it's about, I'm doing this from memory, I've got the number if you're interested, I want to say it's about 4.9 SAIDI minutes on a daily basis. When we exceed that in DEC, that triggers an exclusion or just a separation of the data from an MED perspective. We've seen a much greater impact of ones that get close to that 4.9 but do not cross it. Therefore, all of those outages, customer minutes of interruption and customer interruptions are included in our data from that. So that's a direct impact from that perspective. What I'll share with you, I think you asked a question about self-optimizing grid yesterday. One of the most impactful, well, let me talk about this. So inside the grid improvement plan work, and of course we're going to discontinue the deferral if the settlement's approved, there's really, well, I described earlier, two parts to a distribution circuit: the mainline backbone, the boulevard, and then the tap lines and laterals or the neighborhood streets. Self-optimizing grid focuses only on the backbone, and the reason for that is that's where the most impact occurs when we have an outage or a fault. We call it a fault. Think of it as short circuit, where we have a fault event. And so we have that. For the tap lines, we have other programs that specifically address tap line. Distribution automation, the automated lateral devices, that's very specific for those tap lines. And most of the customers that came to the public hearings and talked about their reliability concerns, they don't live on the backbone, they live on a tap line or in the neighborhood streets. But back to self-optimizing grid, Witness Callahan gave a perfect high-level explanation. That's how I would describe it to someone as well. But let me talk a little bit more about this.
And that's why I didn't ask you. But you can keep going.
I'll say I'll stop, or I can take it further.
No, I didn't mean it that way.
So what's very impressive to me about self-optimizing grid is it does have I tell you what, there's actually, I'm a picture person, visual learner, in Exhibit B of the Grid Improvement Plan Deferral Extension. There's a before and after picture of self-optimizing grid, pages 4 and 5. What you'll see is and I can do this from memory, I remember the picture, or I'll get it really close. The one on page 4 is actually, and I can give you a moment to get there if you like.
I don't know that I can impress you with how quickly I can get there, but I did know where this was.
I say Exhibit B, page 4 and 5. What you'll see on the I'll say the picture on the left, but the first picture on page 4, it essentially shows a couple of circuits. There's a circuit sort of on the left-hand side of the page, and there's a circuit on the right. One's red, one's blue if you have a color version of it. But you'll see the circuit on the right-hand side of that picture, I believe it's circuit B. If we have an outage in that vertical part of that circuit, I want to say there's like maybe 2,600 customers that would be out. You found it. Let me get to it as well, so I'll give you proper numbers here. Okay, I was close. It's 2,691 customers.
Madam Chair, I'm sorry, and maybe this is our fault for not having every exhibit printed. I didn't know if maybe Duke's counsel would have this that they could put on the Elmo. Thank you.
Thank you, Mr. Hall. Thank you, Ms. New.
We all know.
Page 4 and 5 of Exhibit B.
And this feels like a treat to have both visual and auditory at the same time.
Okay. So what you'll see is a circuit A on the left, circuit B on the right. And these circuits do have connections. The red boxes are switches, automated switches like we use in self-optimizing grid, but this is not a self-optimizing grid diagram. And what you'll see if you see circuit B, that vertical section, the blue line, if we have a fault in that vertical section, we would have 2,691 customers out until a crew could respond, find the problem, and make restoration. If you look over, so any questions on kind of that, and then we'll go to, so this is what self-optimizing grid does. And I'm going to bring all this back to your reliability question here in just a minute, but this is important. So you'll see in this updated diagram, again, these are the same two circuits, but we have applied the self-optimizing grid segmentation criteria. And what I mean by that is you see many more of those square boxes. Some are red crosshatched, some are green, and some are red, but they are the same type of device that we use on these circuits. And you see the little lightning bolt there indicating we've got a fault event there in about the same location I described. We still have a fault. We've got customers that are out of power until a crew responds and finds the problem and fixes it. But instead of 2,691 customers having a sustained outage, we have 488. That's powerful. So one of the things that was in some of, I believe it was Witness Mara's testimony, was about the number of circuits that we have under self-optimizing grid control. As of my direct testimony, that was 9%. There has been substantial improvement since then, and I can provide some updates at the appropriate time of where we are with that. And there's really the thing I want to describe now, there's two ways or two big steps that have to happen to get from the first diagram you saw to the second one. First off, it's all the construction in the field. Potential conductor work, the installation of these switches, they all have communications on them. They commission those back to the control center where when the construction crew leaves, all the infrastructure is constructed and the distribution control center operators can see and control those devices, but they have to do it manually. They have to pull up a screen, push a button, give a command, open, close, whatever the case may be. What happens after the construction crews leave is we put this into, we use the term enablement internally, but really to get the team fully activated in automated mode. And that's a substantial lift on the IT side with modeling. They test all the settings from the protection engineers to make sure that wherever the fault occurs on either one of these circuits, by the rules the engineers have put in place, that this will operate correctly. So they model that, test it in a virtual testing environment, and then upload that into production. And finally, the control center operators accept that, and it is live at that point. That process of activation enablement after construction takes typically about 8 to 12 weeks to get that done. There's some intense, complex things that have to happen in that space. And also we do it in a batch environment, so we don't enable one team at a time. They will group them together, do a group of testing, get several teams ready to go, and then they'll do a mass upload once they've done that. So I'll stop there unless there's other questions, but the impact of self-optimized grid, you heard the numbers, 2,691 customers to 488. That is powerful when we have an event on those circuits. That's what will move the needle with us. But again, that's only the backbone. We still have other ways to address tap line outages.
You all are a good team. What
Yeah.
I heard yesterday and then adding the visual and the description is really good to hear.
Good.
Did you say that 9% of what
Of the circuits.
Of the
So in operations and engineering space, we tend to think of circuits. All circuits have a customer count, but that varies. And our goal is we intend to get about 80% of the customers underneath the SOG umbrella, protected by these types of automated systems. That requires about 60% of the circuits to be automated, and we can get 80% of the customers. And that's what's kind of interesting. That's about the same percentage ratio of circuits to customers in all of our jurisdictions. We see the same in the others as well.
So 9% is installed and operational right now.
Fully operational, fully automatic. If a fault occurred while we're sitting here, it would operate the way I described here.
And are you seeing data in SAIDI SAFE results since that 9% went into effect?
We are. We had our reliability governance folks pull some data for the circuits here in DEC, South Carolina, the 9% that we have that have self-optimizing grid. Since they've been enabled, some were enabled in 2020, some are as late as this past year.
Okay.
On average, between those circuits, again, this is only the ones that have automation, we see a 7 to 24% improvement in SAIDI. And that is only from self-optimizing grid.
Is that what you expected?
I would say yes. We expect variability because it depends on the number of faults you have, how much it moves the SAIDI needle. But yes, we expect, on average, double-digit improvement in that. We see that in other jurisdictions. That's not unique to South Carolina. As a point of reference, when we began the self-optimizing grid program we first started talking about it, developing the application guides and other things in 2015, 2016. At that time, I had responsibility for the entire enterprise for self-optimizing grid as far as rolling that out from that perspective. My day job now is to have the engineers that actually do this analysis for the Carolinas, DEC specifically.
Do SAIDI and SAFE include the MEDs?
They typically do not. So the data that we report has those excluded because of the high variability. The graphs would go all over the place year over year and really wouldn't mean a lot.
Okay.
We do have the data with MEDs, but what we look at to trend and analyze how is the system performing, we use without major event days.
You describe what I would call more intense storms that aren't quite the MEDs. If there are more of those, were you testifying earlier they become MEDs?
No, they do
Okay.
not. They stay in that normalized data, and that's one of the drivers we're seeing also of the trend. But we can turn that around with what I just described. I'm doing this at risk. I need to look at the numbers to be sure. About 50% of the customer minutes of interruption that we see in DEC, South Carolina, occur from events on the backbone of the circuit. And that's exactly where SOG operates and where it provides the most benefit from that perspective. So we can have a big impact on that. Does it fix everything? Again, SOG does not address tap lines. We have other things to deal with that, including the corridor vegetation management that we're looking toward.
So as we have more intense storms, if that trend continues, what happens with SAIDI, SAFE, SEALI, or SEMI?
So while there's no guarantees, if we are not doing things such as SOG, et cetera, my words, it would go off the chart.
Right.
I cannot sit here today and say it will bend that curve down and hold it down forever from that perspective. But we've seen the impact of what SOG can do for the circuits that we've deployed it on, and it's very powerful from that perspective. And because it impacts so many customers and improves and prevents them from having an outage, that really moves the needle on system level events from that perspective. And so that's a game changer in that space. Again, we address the individual tap lines. Those are the customers that came and spoke to you all. But again, that tends to be a smaller number of customers. We care about them as well. We've got solutions to address their concerns. But this is where we have the biggest impact for the most customers.
I clearly don't know y'all's world, but from the world that I used to work in that was looking at more intense storms, it may be interesting to pair the data that you've given us in this case with that data as well, because like you said, you don't know whether the self-optimization of the grid there could be two things happening, and one could be good and one could be not so good.
One thing I'll add to that is we do report, and I don't know if you all see this data, but when we have a major event, a true name storm type event, and truly there is the MED exclusions that occur, we still measure, because we can do it with self-optimizing grid, how many minutes of interruption we saved and how many interruptions we saved. And it is amazing the impact that has. So I would share also that besides self-optimizing grid having a major impact on reliability, safety, it's also a huge, what's really neat is it's not only impacting daily reliability numbers in a good way, but resiliency. The ability to take those kind of impacts in a major event, reroute power around them as it occurs, and then once we've got it back up, we can start restoring remotely. We have so much remote control of these circuits and major devices that helps in speed restoration and make the system more resilient in itself.
Okay. Did you tell me if your DEX safety trends are in line with others in the Southeast?
They are in some cases they are higher, so they're worse than that. But you'll see, and I think Witness Mara had this from ORS. He had a table, and it showed DEP South Carolina, DEC, both utilities separated North and South Carolina. If you look at DEP South Carolina, the reason I believe in SOG, they're about 50% of their circuits are underneath self-optimizing grid, and they are one of the better performers in that table. So that's why I feel confident of what impact it can have. I can't predict the future, but we've seen what it's done. And we see that in our other utilities. Again, I had responsibility across the enterprise at one point. We see that in other jurisdictions. Once you've got a substantial penetration, the performance changes.
I've got one last question. It's a little bit more in sync with Commissioner Caston's questions, and it may not be in your world, but are we doing all that we can do with AMI data, and where do we see that evolving if we're not?
So
and feel free to recommend that I ask someone else.
I think I'm not sure who to point it to because I don't know that we have an AMI expert witness from. Okay. So I'll give you my operational view from an AMI perspective. The simplest answer would be no. I don't think we're doing all we can with it. Once you have data and you have new systems and capabilities, you can always find new ways, and our employees are typically the ones that find them and bring them to us saying, have you ever thought about doing this from that perspective? One of the ones I'll give you, this is really a backward-looking example, but the power of AMI and what we can do with that data is what I don't know if I use the term. Internally, we use the term ping it. And once we
ping it,
okay. I don't know who came up with that, but that's what the operators say. What it does is with those remote meters that communicate back to us, we can actually, in blue sky days or fair weather, a customer may call and say, I have an outage. I'm not sure what triggers this, but they could actually, from the call center, they could ping their meter. I don't know what systems they open and what they do, and see if their meter has actual voltage or not. It may be they have a breaker tripped in their house. Maybe the main breaker tripped. And without us having to roll a truck and then say, I'm sorry, you'll have to call an electrician, we can say, yes, you have an outage. We can see that you're out. Or we show that your meter's energized. Have you checked your breaker panel? You may have to call an electrician type stuff. So that's a powerful thing. That helps customers on a normal day. When we get into storm mode, we can see, and the example I think I touched on or alluded to is, as we're doing major events, we use our OMS system to understand how broad the impacts are. We're looking at the breakers in the substations that are open or de-energized, we know we have an entire circuit out. So we focus on getting breakers back online, the big reclosers, those types of things. But when we're sweeping and cleaning up an area, we're ready to roll the crews out. We've got everything, all the infrastructure is repaired. They will actually, the storm operators, not the call center, they'll actually ping all the meters on a circuit to be sure everybody's back on, because there may be at one customer somewhere down a tap line that they're actually, a limb fell and damaged their service or something. We can't see that. The crew never was down that lane. They think they've got everybody back on. They'll ping all those meters and they can see, hey, Mr. Guyton's house is still out, or Mrs. Johnson's house still out. And then they'll roll a crew before they pull out of there and roll to the next area. They'll send somebody down there and look at that from that perspective. And also, instead of, in the old days, we'd call customers back. We think we were cleaning up, and we call them and say, are you still on or off? We don't do that anymore. We use the ping it feature with AMI meters. So I share this example. We never had that before. That's something we figured out. That was not part of the, to my knowledge, not part of the AMI business case. That was something we discovered after we had the system that we could do. Maybe the vendor told us, but there's more we can do.
Mr. Fogg, you look like you might maybe want to add something, so I don't want to keep you from sharing.
If you would allow me to add a little bit more on
Please
OMI.
do.
So your original question, I believe, was how we compare regionally with
Yes.
SAIDI and SAFI. And those are most certainly, distribution metrics. But on the transmission side, one of the industry-wide accepted metrics that we look at is OMI. And OMI stands for outages per 100 miles. And it measures the amount of, the number of sustained outages, which are outages that are greater than 1 minute long, that we have on the system per 100 miles. And it's a metric accepted, nationwide. North American Transmission Forum really kind of governs that metric. And that might not be the right word, governs, but they, we report it to them. And other utilities, co-ops, municipals across the nation support that information too. So in terms of OMI, we do rank out in top quartile performance in OMI. So you were asking how we ranked in terms of SAIDI and SAFI, but I wanted to, in my testimony, I do talk about OMI, and just wanted to make sure that I was answering the question or providing it context on the transmission system and how we rate with OMI. And I'll also add that our OMI performance has been very good, and that's what I relate to in my testimony. And just to kind of tie that back to the vegetation, we do a great job of managing our corridors and executing our right-of-ways and executing our vegetation program. So the events that we're seeing that impact OMI are not from a vegetation standpoint. They are not from trees or vegetation within the right-of-way. They're from fall-ins from outside of the right-of-way. So just to kind of tie it back to our programs and what we're doing from a reactive measure, combined with what we are trying to do from a resiliency effort and from a grid improvement program, will help us in, further strengthen our OMI reliability metrics.
And you testified that DEC is in the top quartile for OMI?
That's correct.
And
nationally.
Nationally, okay.
Yes.
You anticipated that question. Thank you very much. I appreciate all the education and all the answers.
Vice Chair Powers, your light is on. Do you have another question?
I'm sorry.
No, that's okay. Just checking. Is that it? Ms. New, any redirect? Redirect.
Yes, just briefly. Do you recall, Mr. Fogg, you were asked Commissioner Powers some questions about the costs that are shown at the transmission level?
Yes.
Okay, and you were discussing that those are at the system level versus just the South Carolina retail allocation, correct?
Correct.
Okay, and Mr. Guyton, for distribution costs, those are shown at the DEC South Carolina level, correct?
That is correct. They are direct charge based on geographic location.
Okay, and can you explain that a little bit further?
So distribution assets are much more localized from that perspective, and so the ability to actually map those into South Carolina DEC territory versus North Carolina or even DEP or others, we're able to do that. And they typically, distribution facilities only serve those customers. We do have distribution lines that cross the state line. That is, based on the number, that is a rare exception, but there are a few in some areas. And so that makes it much easier for us in distribution to direct charge. The facilities that are physically installed here are serving South Carolina customers. I believe the only exception to that is there is some general plant and intangibles that come into distribution. Those are allocated, but the physical assets that we operate and maintain in distribution are physically here in South Carolina.
Thank you. And so, Mr. Fogg, would you say that the transmission assets then are treated more like generation assets?
Repeat that question, please.
Yeah, so would you consider the transmission assets and that they serve both jurisdictions similar to our generation assets?
Yes, they do.
And so, and is there another witness that talks about how our system costs are allocated?
There is.
All right, can you let the commissioners know who they might want to direct those questions to?
Witness Jiggets may help with allocation of costs.
Thank you. And then, Mr. Guyton, one of the very first questions from Commissioner Williams, you were talking about some of the trends we're seeing with reliability. Do you happen to know on a national basis, are they seeing the same trends in their SAIDI and safety scores across the electric utility industry?
Yeah, so actually, I have seen data, I believe it's based on the IEEE outage measures, which is what we leverage to report our SAIDI and safety. There are a few exceptions in between years, but I think this was about a 10-year history. We're seeing that across the nation with the impacts. And like I say, the challenges we face here are not unique. There are some things that are unique about South Carolina and the Southeast. Others are really global, and so we see that. And so I would say all utilities are having to do something to try and mitigate the impacts of things that they're seeing specific in their jurisdictions, but even the broader impacts. But we are seeing trends tend to move up.
Thank you, gentlemen. That's all I had.
Thank you, Ms. New. Gentlemen, thank you for your appearance and your testimony today. We certainly appreciate the information you've given us, and you may stand down.
Chair, that ends the company's proposed case in chief. Two things as we discussed that, Chair. One, please let us know if the commission would like to hear from any of our other witnesses. We do have witnesses coming back on rebuttal, but that's why I say it's our proposed case in chief. If there's others, let us know.
Do we need to go ahead and do some housekeeping here on stipulated testimony?
Yes, ma'am. That was my second thing. So happy to touch base and start walking through stipulated testimony as well, if you'd like.
All right, sir.
All right. So, Chair, at this time, and I defer to you, Chair. We can go one by one and go direct and rebuttal for each witness.
If we could, so that we can get keep exhibits straight.
Yes, ma'am.
I think that might be the easier thing to do.
Okay, Chair.
Thank you, sir.
So I'll start first with Ms. Shannon Caldwell. Ms. Caldwell filed direct testimony consisting of 28 pages. And she also filed, and Chair, I think I want to make sure I heard you. I was going to hit the exhibits, her direct exhibits second, or would you like me to do testimony, both direct, rebuttal, others, and then exhibits thereafter?
I think when we're just doing the stipulated testimony, I might be able to keep up with doing both testimonies and then the exhibits, although they'll be different.
Got it. Got you, Chair. All right. So direct testimony consisting of 28 pages and rebuttal testimony consisting of 34 pages. That ends her testimony.
Hang on a second, I'm trying to find her on my line. Okay. And we've got verifications of all these folks that'll be given to the court reporters, right?
Chair, either they are filed or soon to be filed.
I think I saw them filed on the DMS this morning. So.
They are filed, Chair.
Okay. Ms. Caldwell's direct pre-filed testimony will be entered into the record as if given from the stand, and her rebuttal testimony will also be entered as if given from the stand.
Thank you, Chair. Ms. Caldwell also filed or pre-filed 2 direct exhibits.
Ms. Caldwell's direct exhibits will be a composite exhibit marked for identification as hearing exhibit 26 and entered into the record of the case.
And Ms. Caldwell also pre-filed 1 rebuttal exhibit.
And Ms. Caldwell's rebuttal exhibit will be marked for identification as hearing exhibit 27 and entered into the record of this case. Thank you.
Thank you, Chair. I'll move on to Mr. Jeffrey Kopp next. Mr. Kopp filed rebuttal testimony consisting of 17 pages.
Mr. Kopp's rebuttal testimony will be entered into the record as if given from the stand.
And he filed one rebuttal exhibit.
Mr. Kopp's rebuttal exhibit will be marked for identification as hearing exhibit 28 and admitted into the evidence of this case.
Thank you, Chair. I'll move on next to Mr. John Panizza. Mr. Panizza filed or pre-filed direct testimony consisting of 13 pages.
Mr. Panizza's direct pre-filed testimony will be admitted into the record as if given from the stand.
He had no exhibits, Chair, so I'll move on to Mr. Mark Rokoff. Mr. Mark Rokoff pre-filed direct testimony consisting of 4 pages and rebuttal testimony consisting of 24 pages.
Mr. Rokoff's, I'm sorry, can't spell. Mr. Rokoff's direct testimony will be entered into the record as if given from the stand, and Mr. Rokoff's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Thank you. And then Mr. Rokoff filed 2 direct exhibits.
Mr. Rokoff's direct exhibits will be a composite exhibit marked for identification as hearing exhibit number 29 and admitted into evidence of this case.
Thank you. And then 2 rebuttal exhibits.
Mr. Rokoff's 2 rebuttal exhibits will be a composite exhibit marked for identification as hearing exhibit 30 and received into the evidence of this case.
Thank you. I'll move on next to Mr. John Spanos. Mr. Spanos pre-filed direct testimony consisting of 22 pages and rebuttal testimony consisting of 36 pages.
Mr. Spanos' pre-filed direct testimony will be entered into the record as if given from the stand. Likewise, Mr. Spanos' pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Thank you. And then Mr. Spanos pre-filed Appendix A, as well as 2 exhibits to his direct testimony.
Mr. Spanos' pre-filed exhibits, which contain an Appendix A and then 2 exhibits, will be marked for identification as hearing exhibit 31 and entered into the evidence of this case.
Thank you. I'll move on next to Mr. Nicholas Spiros. So Mr. Spiros pre-filed direct testimony consisting of 8 pages and rebuttal testimony consisting of 39 pages.
Mr. Spiros' pre-filed direct testimony and his pre-filed rebuttal testimony will be entered into the record as if both were given from the stand.
Thank you. And then Mr. Spiros pre-filed 2 direct exhibits.
Mr. Spiros' pre-filed direct exhibits will be a composite exhibit marked for identification as hearing exhibit 32 and received into the evidence of this case.
Moving on to Mr. Robert Veet. Mr. Veet pre-filed rebuttal testimony consisting of 27 pages.
Mr. Veet's pre-filed rebuttal testimony will be entered into the record as if given from the stand.
Mr. Veet also pre-filed 1 rebuttal exhibit.
Mr. Veet's rebuttal exhibit will be marked for identification as hearing exhibit 33 and admitted into the evidence of this case.
Thank you. I'll move next to Mr. Brian Walsh. Mr. Walsh pre-filed direct testimony consisting of 25 pages and rebuttal testimony consisting of 14 pages.
Mr. Walsh's pre-filed direct testimony and pre-filed rebuttal testimony will both be admitted into the record as if given orally from the stand.
Thank you. He had no exhibits, Chair. So last but not least, I'll move on to Ms. Marcia Williams. Ms. Williams pre-filed direct testimony consisting of 60 pages and rebuttal testimony consisting of 35 pages.
Ms. Williams, direct testimony, pre-filed direct testimony and pre-filed rebuttal testimony will be admitted into the record as if given from the stand.
And Ms. Williams pre-filed one direct exhibit.
And Ms. Williams' pre-filed direct exhibit will be marked for identification as hearing exhibit 34 and received into the evidence of this case.
And Chair, that covers all of the company's stipulated testimony and exhibits. Thank you.
Okay.
Madam Chair, may I ask counsel, did we put in Mr. Duff's rebuttal when he testified?
Yes, sir.
Okay, thanks.
Yes, I've got it marked off, so I hope that means we did.
Yes.
Any other questions, concerns? Okay. So from here, that completes the company's case in chief. Is that correct?
Yes, Chair, we do have, as you know, some panels coming up for rebuttal, but that does complete our case in chief, subject to the commission's additional inquiries.
So, and I believe we have completed with the intervener witnesses except for the DCA's witnesses. Is that correct? We've got, say, CCL, we got Walmart, we got energy users. Is that correct? Okay. So we've still got DCA's witnesses, ORS witnesses, and rebuttal. All right.
That's my understanding.
Now, it's 12:30. I don't think we would finish the next panel by by one.
Just one witness, and I don't think we'll even finish. We'll even finish them by one.
Okay. Wait a minute.
We have two witnesses, but we're not presenting them as a panel,
Okay.
and they're both virtual.
I'm sorry. Thank you for that. You don't think we would finish one of them by 1 o'clock?
I doubt it.
Okay, that's fine. I just want to make sure. Trying to maximize our usage. Ladies and gentlemen, I know I usually like to give an hour and 15 minutes for lunch, but do you think we can be done with lunch in an hour? Just we need to finish by 4 this afternoon, so I don't want anybody to be dangerous, but let's break until it's 12:30, 1:30, and if anybody has any difficulties, alert somebody that's already back here so they can let us know. Okay. See you at 1:30. Thank you very much.